Call this meeting to order. I am Commissioner John Tuma. Unfortunately, been thrust upon you as can you hear me back first? No here. That's why we get these.
Commissioner Tuma, I can't hear you very well.
We're working on that, Joe.
But they're not working.
Okay.
Mic is on. That's not, staff is so good. I mean, look at that. It's on. Unmute yourself, Commissioner. How are we doing?
Muted.
I'm going to keep talking until they tell me in the background, and you, Joe, tell me it's good. Good, Joe? It sucks that the Twins lost 3 in a row to L.A.
I heard that.
Worse
Not
than
very
that,
loud.
they lost 2 games to the Rockies, too. So, okay. We are now in the meeting of the Public Utilities Commission of Minnesota. We have our Thursday, July 24th meeting. I will take the roll. Commissioner Partridge.
Here.
Mr. Hom.
Here.
Mr. Sullivan.
Here.
And I am here under duress, as I found out last night. Vice Chair was not feeling well, so I hope you're feeling better, Joe. But he wants to be here because we got some big issues in front of us, so I appreciate you taking the time to do that. And so I am going to be chairing. We're going to take our time. Please be understanding, forgiving as I try to keep the meeting moving forward today. So with that, let's introduce the first item.
Good morning, Chair Tuma and Commissioners. Item number 1 is docket number E123/C-25-219 in the matter of a formal complaint by the Upper Sioux community against Minnesota Valley Cooperative Light and Power Association. The question before the Commission is, should the Commission investigate the formal complaint by the Upper Sioux community against Minnesota Valley Cooperative Light and Power Association? Cure and Mencia both filed their preferred decision options earlier this week on Monday the 21st and Tuesday the 22nd. Commissioner Tuma also filed 2 new decision options on July 22nd, and Commissioner Sullivan filed a proposed modified decision option this morning. All of those preferred and new decision options have been compiled into a modified list of decision options, which has been filed and is available in a hard copy at the front of the room. There was also a notice of oral arguments filed for this item, and staff is available for any questions.
Thank you. Parties, come forward. Those of you who are online, turn your cameras on. Do the awkward, I don't know where I'm going to sit. It's okay. You can sit anywhere. Those of you who haven't been in front of us, there is a little on button on your thing. It should glow green, I think is my understanding. But you just saw my staff worried about whether I'm on, so you can tell I'm not the technical guy. We have a list for oral arguments. We will have Upper Sioux 4 minutes, the co-op 4 minutes, and I have Alliance for everybody else is 2 minutes. Alliance for Tribal Clean Energy, Cure, Fond du Lac, Midwest Tribal Energy Resource Association, Minnesota, Mencia, Tribal Energy Alternative, White Earth, Wolf River Electric, and then 4 minutes for the department. And so with that, Upper Sioux, Mr. Rasmussen.
Good morning, Commissioners. Thank you for the time this morning. My name is Leif Rasmussen. I represent the Upper Sioux community. Leif is L-E-I-F, Rasmussen, R-A-S-M-U-S-S-E-N. It's just a very brief opening statement. I know in the PUC's staffing papers before this hearing, they talked about this hearing was not about tribal sovereignty. From the Upper Sioux community's perspective, that's all that this hearing is about, is tribal sovereignty and the tribe's right to self-government and self-determination. In the 1970s, the state of Minnesota drew up geographical boundaries for electric service providers. Those are civil regulatory laws. They do not apply within the Upper Sioux community, nor do they apply with any other tribal nation in this state. The The Upper Sioux is asking the PUC to acknowledge this inherent sovereignty and to inform all power producers in the state of Minnesota that they need to negotiate service contracts with the separate tribes. If Minnesota Valley Light and Power Association does not want to provide power to the Upper Sioux community because the USC is building for their own purpose a 2.5 megawatt solar array behind the meter, if they don't want to say, no, we're not going to provide power from the Upper Sioux community's perspective, that's fine. Then PUC, let Xcel or someone like Xcel come in and provide power. I'm sure they will do it. And once again, these are civil regulatory laws that don't apply within the Upper Sioux community. And the Upper Sioux community would ask that the PUC inform other power providers that they can provide power then to Upper Sioux community. I mean, obviously the tribe would love to stay with the co-op, but if the co-op is going to take this position, they just as soon get their power from someone else. I have nothing further at this time. Any questions you'd like to ask?
We'll reserve questions for after opening statements, so. Co-op, please.
Good morning, Commissioners. My name is Matthew Hogan. I'm an attorney at Nelson, Oyen, and Torvik Law Offices in Montevideo, Minnesota. I represent Minnesota Valley Cooperative Light and Power Association. I would also like to thank the Commission for having the opportunity to be here to respond to the formal complaint that has been filed by Upper Sioux. I'll begin with just a little bit of background about Minnesota Valley. Minnesota Valley is a member-owned, nonprofit electric cooperative organized under the laws of the state of Minnesota. It has 3,260 miles of electric power lines here in the state of Minnesota and 5,250 members in 8 counties in western Minnesota. Minnesota has a defined service territory, as Mr. Rasmussen had indicated, which includes the property owned by the Upper Sioux community. Pursuant to Minnesota Statute 308A.301, Minnesota Valley is governed by a board of directors. Minnesota Valley has 7 directors that are elected at its annual meeting. Minnesota Valley's rates or service conditions are approved by the Public Utilities Commission, but instead, pursuant to statute, are approved by the Board of Directors. The Board of Directors also set terms of service through board policies. Minnesota Valley's board has enacted board policies on this issue, which are approved by Minnesota statute. It regulates cogeneration that is being proposed by the Upper Sioux community. These policies only allow behind-the-meter cogeneration up to 40 kW. This policy is consistent with 216B.164. Minnesota Valley will allow solar cogeneration in excess of 40 kW, which is being what's proposed by the Upper Sioux community, but pursuant to its policies does require that any excess cogeneration either be sold to some outside third party or not used by a member of Minnesota Valley. These policies have been thoroughly explained to the Upper Sioux community even before it began its process. Minnesota Valley has discussed with Basin Electric, who is Minnesota Valley's wholesale electric provider, to purchase this excess cogenerated power at excess of 4 kW and has agreed to transport it through transmission lines and charge a reasonable market wheelage rate to do so. Minnesota Statute 216B.164 Subdivision 3 provides the rules that apply to an individual or entity that wants to cogenerate behind the meter as the Upper Sioux community has provided. The statute differentiates for different types of public utilities. Subdivision 3 applies only to cooperative electric associations like Minnesota Valley and municipal utilities. The legislature was clear that we need to treat these entities different than Xcel Energy or some of the other bigger public utilities that serve this area. It provides that for a facility having less than 40 kW capacity, the customer shall be billed for the net energy actually provided to that customer. Minnesota Valley's board's policies are consistent with 216B.164. Further, subdivision 11 of that specific statute, the last sentence specifically states, a cooperative electric association that has adopted a resolution and rules under this subdivision is exempt from regulation by the Public Utilities Commission under this section. Minnesota Valley has that board policy in place. It has adopted it. The legislature was clear here in what type of cogeneration could occur in an electric cooperative like Minnesota Valley. And it was clear about what jurisdiction or lack thereof the Public Utilities Commission had in regulating this type or this area of cogeneration. To Mr. Rasmussen's comments, the Commission asked for any agreements that were referenced in letters that were filed or provided to the Upper Sioux community about sovereign immunity. There were 3 agreements that were provided to the Commission. In these agreements, the Upper Sioux agrees to be a member of Minnesota Valley, agrees to be bound by its articles of organization, its bylaws, and its board policies, and very specifically in one, specifically waives any sovereign immunity it may have as a Native American organization. If the Upper Sioux were allowed to operate this behind-the-meter solar cogeneration as they have proposed, it would result in reduced revenue for Minnesota Valley. This would result in embedded costs that have already been incurred by Minnesota Valley to be shared with other members. Minnesota Valley currently has 39 members that are co-generating. Each of them is less than 40 kW. Many have asked to co-generate in excess of 40 kW and do net metering as proposed by the Upper Sioux, but each time Minnesota Valley has provided its board policy and specifically stuck to what the statute specifically allows. Minnesota Valley always has and always will be willing to work with the Upper Sioux community. It values its relationship that it's had since 1990. Minnesota Valley is here asking the commission to find that it doesn't have jurisdiction, to decide not to investigate further, and dismiss this matter without any further hearings.
Next I have the Alliance for Tribal Clean Energy. Are they on? Apparently not. Mr. Hudson Kingston from Cure. I guess you're next. I got a second list here. Like I said, I've taken up. It's a little slow on the go here, but Mr. Kingston, state your name for the record, who you represent.
Absolutely. Can you hear me all right?
I can.
Wonderful. Chair Tuma, Commissioners, my name is Hudson Kingston, speaking on behalf of CURE. Thank you for allowing us to make an opening statement. This is an important matter for the Commission to take up as it regards the standards for co-ops and all member owners who would like to take advantage of energy efficiency, energy storage, or even distributed generation. As such, we think the Commission should choose decision options 1 and 3 and initiate an investigation. We do not believe that a contested case hearing is necessary at this point. Instead, we think that the Commission can proceed using decision options 9, 6, and the 2 more specific options from Commissioner Tuma, 6A and 6B. By first consulting with TACE, the Commission can get a deeper understanding of how this is playing out with tribes and can learn from TACE the ways to solve this problem without any material harm to Minnesota Valley or the Upper Sioux community. Upper Sioux has done everything by the book in this case, and it deserves the Commission's full attention and assistance in resolving this matter. We believe that there's a potential for a resolution here that serves the interests of both Minnesota Valley and its large member owner. There is no reason that this dispute has to end with lasting financial harm to either party. But first, the Commission will have to set expectations and make it clear that Upper Sioux cannot be disconnected for doing something that is good for their members, their business, and their environment. Upper Sioux should be empowered to assert their energy sovereignty and renewable energy goals in coordination with the utilities that serve their lands. Thank you for your attention, and I would be happy to answer any questions.
Thank you. For the Fond du Lac Band, Bruno Zargar. Right next to Mr. Rasmussen, there's a seat for you.
Morning, everyone. Is this turned on?
I don't think it is because you're not, camera's not picking you up.
Oh, it was on. Okay. Good morning, Commissioners and everyone. Thank you for giving Fond du Lac Band of Lake Spirit Chippewa an opportunity to provide a brief comment. The Upper Sioux tribal community has the right to install the 2.5 megawatt solar project with battery storage and switchgear. The only reason we are here today is that Minnesota Valley Electric Co-op is threatening to turn off power, which is illegal by state of Minnesota statute, and is using the threat to stop Upper Sioux tribal community from installing a solar project that complies with Minnesota state energy law. Minnesota Valley Electric Cooperative has no jurisdiction on tribal land and should not be interfering with the installation of an Upper Sioux tribal community solar project. Minnesota 100% carbon-free energy law requires cooperative utilities to comply with carbon-free energy goals. The Fond du Lac Band of Lake Superior Chippewa supports Minnesota Public Utility Commission's modified decision options 1, 3, 6, and 8. In addition, the Fond du Lac Band supports the new decision option 9 submitted by CURE before referral to a contested case hearing and prior to concluding an expedited investigation, refer the issue to an interconnection barriers on the tribal clean energy projects to the Tribal Advisory Council on Energy. TACE will provide guidance on issues relevant to all tribes that will assist with dispute issues in the future. Thank you for your time and consideration on this matter that will affect all Minnesota tribes.
Mr. Zagar. Mr. Zahn.
Thank you.
Good morning, Chair Tuma and Commissioners. My name is Curtis Zahn. I'm here on behalf of MNCEA. Thank you for giving us an opportunity to provide a brief opening statement. MNCEA believes that this matter can be resolved by a plain reading of existing Minnesota and federal law. Following existing law recognizes the Upper Sioux community's sovereignty and right to provide for the welfare of its people without causing Minnesota Valley to violate its contract with Basin Electric or anyone else. State and federal law explicitly require all utilities to allow all people and nations living within the boundaries of the state of Minnesota to operate their solar facilities in parallel with the utility system if the solar facility is less than 10 megawatts under Minnesota law or 80 megawatts under federal law. The Upper Sioux community's project is only 2.5 megawatts, and because the community has designed its system so that it will not be exporting any energy, Minnesota Valley will not be buying any energy from Upper Sioux. They will simply be selling Upper Sioux less energy, which is no different than if Upper Sioux improved its energy efficiency or otherwise limited its operations in a way that reduced its energy demand. Excuse me. Nothing is in the record demonstrating that Upper Sioux is required to buy a specific amount of energy from Minnesota Valley. However, Minnesota law requires all utilities to provide, quote unquote, electric service to their customers in a reasonable, sufficient, and just manner. For these reasons, MNCEA supports Upper Sioux's request to require Minnesota Valley to allow to operate its solar facility and not disconnect or otherwise limit the energy Minnesota Valley supplies to the Upper Sioux community. Thank you.
Thank you, Mr. Zahn. Next, from Wolf River Electric. State your name for the record. I didn't pronounce your name because I think I would probably get it wrong, but so state your name for the record, and hopefully I'll get it right from here on out.
Good morning, Chair and Commissioners. My name is Nicholas Kasparovich, General Counsel for Wolf River Electric. Thank you for allowing us the time to speak on this matter today. Wolf River Electric believes in a simple principle. Everyone should have the freedom to harvest the sun and generate their own clean electricity, especially sovereign indigenous nations and the citizens of this great state of Minnesota. An important matter appears to have been largely glossed over in the briefing on this matter. In response to the choice of one business, just one building, to offset some of its electricity needs with solar, Minnesota Valley has threatened to shut off electricity to an entire sovereign nation, which no doubt consists of individuals, families, businesses, and the tribal government. As a cooperative utility, Minnesota Valley's sole purpose in existing is to provide power to its community members. Not only are Minnesota Valley's actions retaliatory and dangerous, it is blatantly discriminatory against the entire Upper Sioux community. The Commission has asked whether it is in the public interest to investigate the Upper Sioux community's allegations. Wolf River Electric cannot imagine what could be more in the public interest than investigating this threat to cut off power to the entire sovereign nation, simply because of the choice to utilize a solar system. We ask that the Commission make a swift determination that it has jurisdiction over Minnesota Valley and take immediate action to prevent the cooperative from this historic threat of shutting off power to the community that it has been charged with serving. Thank you.
Ms. Arnold.
Good morning, Chair Tuma, Commissioners. Catherine Arnold, Assistant Attorney General for the Department of Commerce. The Department appreciates the time and attention that not only the Commission, but so many of the parties who have commented have put into considering the complaint and the concerns that it raises. From the Department's perspective, the jurisdiction question is clear. The complaint squarely falls within the statutory provision that extends the Commission's jurisdiction to cooperatives when the complaint involves service standards and practices. There is also broad consensus among the commenting parties that the Commission should investigate this complaint. Minnesota Valley was the only commenting party who argued that the commission should not investigate the complaint, and the arguments that Minnesota Valley made, such as whether they have an all requirements contract with Basin Power Electric Cooperative and whether they are treating the Upper Sioux community differently than other customers, are based on Minnesota Valley's own view of contested material facts. Of the questions the commission identified in its notice of comment, the only one where the department differed from the majority view is on the question of what procedure the commission should use to investigate the complaint. The department appreciates the Upper Sioux community's sense of urgency to have a resolution to this question. However, the department remains concerned with the depth and breadth of unresolved questions of material fact and believe that an expedited process is a poor fit for the facts of this case. In the department's initial comments, we provided several examples where we believe that there's further development of the record needed, such as the relationship between Prairie Ridge Casino and the distributed generation facility, which entity or entities Minnesota Valley intends to cut off from power if the community continues the construction and operation of the facility, the terms of Minnesota Valley's contract with Basin Electric, and whether the design on the solar generation and battery energy storage facility ensures that it will only operate as a behind-the-meter, not-for-export system. As comments from other parties were submitted, additional serious questions arose. For example, Wolf River's comments state that Minnesota Valley instructed its outside engineering contractor to revise their study in order to artificially create a barrier to approving the tribe's project. That's a very serious allegation, and we think there needs to be record development there. The department appreciates the intent of the parties who have suggested additional processes, such as rulemaking, government-to-government consultation, and referral to TASTE for input. However, both the PUC and the department are already required under state law to consult with the tribes. The department, and to my understanding, the PUC has long been aware that there's been friction between many tribes and the rural electric co-ops that serve them, but given the limited jurisdiction that generally extends over co-ops, this particular situation being an exception, there is not much that the department or the PUC has been able to do to resolve those issues in the past, and our understanding is that having those processes or those consultations would simply use tribal time and energy without a resolution that is going to be addressing their concerns, which is why we're not supporting those decision options. With regards to New Sullivan Decision Option 5, the department is generally supportive, but we have some modifications to the third question that we believe would be appropriate, which we can get into now or later. Thank you.
Get that later. So, thank you. And I want to thank you, Ms. Arnold, for your initial comments. They were helpful, particularly the Taylor decision. I read that closely, and you've laid this out as that would be as the commission has authority to investigate pursuant to Minnesota Statute 216B.17, particularly Subdivision 1 and then 6, I think 6A, if I recall. That we still have jurisdiction over policies, okay? The history of this is in 1974, the legislature decided, one of the last states in the union, to actually create a regulated service territory exclusive, jurisdictional orientated system in Minnesota where everybody has their jurisdiction lines, and back in 74 we laid them out. We regulated at that time everybody but munis, okay? Cooperatives were involved. 4 years later, after much lobbying, the legislature changed that, okay? That's what Taylor kind of highlights. So I appreciated that reading and the history from him. And that we reserve, the legislature told us we reserve the duty, very heavy duty, not to set policies. They get to set policies, okay? But it clearly that we were to be able to look at standards and practices, okay? That was 6A. And whether they're reasonable, sufficient, unjustly discriminatory, or that any service is inadequate or cannot be obtained. I don't know what cannot be obtained means, but it sounds like shutoff might be one of those. I'm just kind of curious whether it is or not, but that was what not Taylor. Taylor was about discrimination between interconnection fees, my understanding, correct me if I'm wrong, Ms. Arnold, there was interconnection fees between mobile homes and regular homes.
That's correct.
And even though it was a fee, which looks close to a tariff. The Supreme Court said, no, there's a policy underlying that, and the legislature said that is still retained after 1978 by this commission. Also, at that time, they actually allowed certain activities to occur where members could actually petition to stay rate regulated, and hence why we still have Dakota Electric as a rate regulated entity in Minnesota. So I appreciated the Taylor decision, but that goes to you, Mr. Rasmussen. Okay, I'm here. I'm assuming you have reviewed the Taylor decision. Have you?
Yes, I have.
And so I'm sitting here looking at those statutes, and you brought something before me, and I'll be perfectly honest with you. I read your initial filings, all of them, okay? And I've listened to your opening statements. And so I want to have clarity going forward in our discussion today, okay? You've raised a very important sovereignty issue, an issue that I know in her absence today, the chair would want me to point out that we've taken that very, very seriously. And she has asked us to do consultations on a regular basis with tribal communities. It's difficult because we're quasi-judicial, quasi-legislative, and so we have challenges. I view us here today in a very quasi-judicial position, okay? Making a very quasi-judicial decision on a complaint that you have, a concern that you've laid out in front of us. Am I missing it somehow?
No, Mr. Commissioner. I guess, and I wish I could speak. The chairman was here who could explain it a little bit better than I. Is the Upper Sioux community has started this whole process, frankly, as a courtesy to the co-op and as a courtesy to the state of Minnesota to follow these procedures to potentially get a resolution of this issue. We certainly don't waive any sovereignty as we have to the co-op or to this commission. We feel the laws that have been referenced here today don't apply within the exterior boundaries of the tribe. However, we always clearly acknowledge that the commission does have jurisdiction over the co-op. So whatever assistance this commission can give to the Upper Sioux community by applying its jurisdiction over the co-op would be helpful for the tribe.
But you brought this, the filing came from you, okay, which I appreciate. Now we have a duty. How do we dispose of it in a very judicial sense is what I'm trying to say. We're not here trying to make policy on state sovereignty, or we're trying to resolve a dispute, okay? So I'm not in my legislative function. I'm in my judicial function with something you filed with us.
I agree with that statement. We would, I guess, ask that the PUC, following its laws, its rules, would judicially decide, if that's the right term, to inform the co-op that under the laws that apply to the co-op, not necessarily the tribe, but the laws that apply to the co-op, that they do not have the right to turn off power to the tribe if the tribe decides to turn on, and will turn on, a 2.5 megawatt solar array only for their own use. No different than putting in different light bulbs that reduces their electrical.
I get that. So we're tracking. Yeah. I want to make sure I'm moving forward. There's a lot of discussion about consultations, and I can tell you we have been taking that very seriously. We've been having internal conversations actually since the Lower Sioux actually had a gas line, distribution line sent to their reservation to run their casino in a government building, and we started to decide what is our relationship when that happens, okay? What authority do we have? And we've been asking those questions and trying to understand that so that we can treat the sovereign nations that are our partners here in our community, okay? They're here, they're within our boundaries. How can we work with them appropriately? And we've been very serious about that. And there are some questions that we'll have to decide, but every jurisdiction that we're talking about now looks quite different. Your client, the Upper Sioux, looks a lot different than White Earth, which looks a lot different than Red Lake, which looks a lot different than, say, Grand Portage or or the Prairie Island, okay? All different mixes of different situations that we got to use. So I have a very fact-specific, what I view as a desire, a complaint from you, okay? Now, when I read our statutes limit us to bring complaints in front of us over their policies, okay, or their standards and practices is what the statute says, 50 customers, or on our own motion, okay? So you can bring something and say, this is so bad, it's affecting a sovereign nation. You, commission, should look at this in total. It's important for us right now, for our problem we're having right now. I appreciate the fact we should look at the bigger picture. But so sovereignty plays a role in that, okay? But it is your complaint to us to take up, well, I view it this way, maybe you don't. This is what Ms. Arnold laid out when she cited Taylor. That's the way I see it, that we're supposed to follow our statute requirements under 217B, subdivision 17, 1 and 5B. And it says that we are to essentially investigate, and the court in Taylor says adjudicate. Doesn't mean we have to adjudicate, but it says we can investigate. I think it is, we can. I think there's a duty there. I take my role here very seriously. If a sovereign country comes to me, a sovereign nation, or comes to us and says, we got a problem, I view that as a duty responsibility. So, and then what I have to do is investigate cooperative standards and practices, whether they are unreasonable, insufficient, or unjustly discriminatory, or that any service is inadequate or cannot be obtained. I assume, based on what I've seen, but it's not clear, that's what we're doing right now. You may have other actions in district court or in federal district court or whatever, but what I have is a 217B subdivision 1 6A problem you're asking me to take up on our own motion to investigate and adjudicate to whether their actions were unreasonable, insufficient, or unjustly discriminatory, yada, yada. Are we tracking?
We are tracking. That's exactly right. We're asking the PUC to take up that decision-making under their laws as those laws apply to the co-op. And yes, from our position, is what they're doing is discriminatory and in violation of their services and practices.
Overlay over that, of course, is the sovereignty question that we are all trying to figure out, which I agree with you, looked a whole lot different in 1974 than it does today. I'm not naive to that. I grew up not too far from Prior Lake. I understand the ugliness of prejudice. I'm still trying to figure out what that means and learn as I go. And I've appreciated particularly the Upper Sioux's advice to me over the years. They have been wonderful. I did my training up there that we all do to figure out what is this relationship. So I take that seriously, okay? But it's an overlay over a dispute that's in front of us. Would you agree with that analysis?
I would agree with that, yes.
So I know you got your hand up, Commissioner Sullivan. I want to get through this one question and then I'll go to you. It's a little lengthy, but if you want to talk about this subject, I don't want to cut you off, Joe.
I'm good. I am really struggling to hear folks.
Oh.
So I don't know if it's the microphone, but I really, it's very hard.
Are you hearing me, Joe? That's what I want to make sure, or am I need to get closer?
I can hear you, and I can hear the microphones at the testifiers table, but it's very hard to hear you guys.
Okay.
It's like the opposite of the Spinal Tap 11. It is.
So we'll try to, if you could, everybody try to speak into your mics a little bit clearer, and we'll try to do our best. Sorry about that, Joe. To the cooperative, I'm looking at that statute, and I'm looking at the Taylor decision. I'm assuming you reviewed Taylor for this hearing.
I have reviewed it.
And it was 1982. The court said, basically the commission's investigation and subsequent adjudication that an interconnection fee in that situation of a cooperative was unreasonably discriminatory. And following from that, I'm saying that specifically Minnesota Statute 216B17 subdivision 1, 6A states, you get to set the policy. Okay, got that. We don't get to rate regulate you. Okay, unless you petitioned to done it, and you didn't. Okay, so you're not rate regulated. Don't want to regulate your rates. But we have the duty to investigate cooperative standards and practices to determine whether they are reasonable or unreasonable, insufficient or unjustly discriminatory, or that any service is inadequate or cannot be obtained. And the court in that, I thought, was quite clear on why this was to the co-op. They said, citing a series of cases, okay, on the Rural Electrification Act of 1936, and it said, implicit in the purpose of this, which cooperatives are authorized by the Rural Electrification Act of 1936, that of supplying electric energy and promoting and extending the use thereof in rural areas is an obligation of each cooperative to make membership available without arbitrary or unreasonable limitations thereon, to all coming within the purview of that purpose. So it seems pretty clear the overall purpose of that law was to keep people connected. You're using PURPA, which was specifically created to force you to take people on, okay? It wasn't to eliminate it, so I'm looking at the whole panoply of the authority here and trying to understand how you can say many members of Minnesota Valley in the past have requested to build a power generation solar array of 40 kilowatts or more capacity in Minnesota service territory and were denied because it is inconsistent with Minnesota law, which I would dispute, Minnesota Valley's Articles of Incorporation and bylaws, and Minnesota Valley's board policy. So in light of Taylor, how are you exempt from us investigating and adjudicating?
Commissioner Tuma, I will try to respond. There's a lot of different points that you're going to try to answer. If I miss some, please follow up. First thing, I do agree.
Excuse me, sorry. Chair Tuma, could you please put your mic close to you, because I think the people online are struggling to hear. Just
pull the mic right in front.
Very loud.
They can't hear us, though. Our mics are not
I think they
good.
want you to be loud, so we'll go for it.
Well, I will try. But anyways, commissioners, I would agree we are in a quasi-judicial type situation here. I would ask the commission to look at statutorily what jurisdiction you have in this situation. I don't have the Taylor case in front of me. I understand generally what the findings are, and I don't necessarily disagree with you. But I think when you are in a quasi or judicial type situation, you need to look at what jurisdiction you have. No different than if a court of appeals has a jurisdiction to hear an appeal. You need to look, at least in my respectful position, to what the legislature has allowed you to do. Subdivision 11 of 216B.164 specifically indicates a cooperative electric association that has adopted a resolution and rules under this subdivision is exempt from regulation by the Public Utilities Commission under this section. So we're talking all about 216B.164. We're not talking about subdivision 11A. We're talking specifically about that. Here, Minnesota Valley has exercised that authority, has adopted a board policy, and so I would respectfully...
So just so I understand that, so 216B.164 you think gives you authority to tell someone doing something behind the meter, if it's a farmer, maybe you have a large farm. I grew up with farm guys all around me. Every one of them had a generator. Okay? The reason why, because power goes out, okay, and you don't milk your cows for a couple days, they start to dry up. Every one of them had a generator. Okay? A lot of them, I would gather, probably in cooperative areas. Okay? Are you saying that you, under 164, had the authority to tell farmers what they can do on their farm with generators?
Respectfully, I think the generator...
Behind the meter.
I think the generator situation raises a number of issues. The instance that you're referring to would not be cogeneration, I'm assuming. I'm assuming the farmers that you're referring to is the power's out, now we are going to generate until the power comes back on. Would you agree?
Could be. It's a generator. The cogeneration you're saying here is It's a generator. Okay? They're using it to supply their need.
Right, but they are supplying their need at the same time Minnesota Valley is also providing them power.
So is your concern that this is a safety issue that is really not behind the meter? Or are you just saying nobody behind the meter can have their generator running at the same time power is on?
I think it's twofold. I think safety is one issue. We need to be careful. I mean, electric power is a dangerous thing if not used correctly, and we need to have standards in place, especially when we're talking this large of power, and this is a larger load.
And hence they came to you with an application. I'm going to guess, Wolf River, that's why you came to them and did an application. Your engineers probably wanted to make sure we don't have any power when the power is out. This is what we hear from Xcel all the time.
Yes,
when
absolutely,
power's out,
Commissioner.
we want to make sure it's safe, that because we could be islanded and we could be producing while there are linemen out there hurrying quickly to try to get power back to the rest of us. So I'm assuming that's why you went to
That
them.
is the only reason we went to them, and that is why they request we do it in the first place. Not to mention, this was all engineered to be done safely, properly, all with licensed electricians, master electricians, stamped, engineered, approved, and submitted for inspection.
Now, you said that you haven't seen the final engineering reports, at least that's what I read in your thing. So we really don't know what the engineer says with regards to this island effect, the safety question. Is that your understanding?
We have not seen the final report for the engineer report on the impact on the grid, but we have done independent engineering of the system itself.
So you're saying it's going to be safe in an island situation. Linemen shouldn't have to worry, but they should have insight that you're existing, right?
Yes, Commissioner.
And I think just what I'm going to hear from you, do you dispute that? I mean, you may have seen the engineering. Do you agree that there is a safety issue here, or that, I mean, that's a fact question I need to know, is it truly behind the meter? And are you saying that's still a fact question that's up for understanding?
I believe behind the meter would still be a safety issue. I'd like to get back to your comment. You did reference the rural electrification.
I wanted to get the behind the meter thing resolved because I think that's
I couldn't hear what he said, if it was behind the meter or not.
Go ahead. He did. He said
Yes,
it's a safety
I
issue.
believe it would be a safety issue even behind the meter. It's all interconnected to the same system, that being proposed by the solar array and also supplied by Minnesota Valley's transmission line. So the answer was yes, sir.
And that's an important fact dispute. I could get to a point where I could say, if that fact is not disputed, there's an argument here that we have authority. You're saying not, and that's the next phase. I just wanted to be very clear on that you feel that's a fact dispute, and we're good. Now you can proceed.
The other thing I wanted to note, and I hope Commissioner Sullivan, if you can't hear me, I will try to speak louder, is this is a very rural area. The Rural Electrification Act of 1936, as I understand it, was passed because no one, the Xcels, the Otter Tail Power Companies, the other ones, found it profitable to serve these rural areas. So that's why we had the government step in, and that's why you have these defined service territories. Upper Sioux community is in that defined service territory. And this is a situation where if they do reduce their power demand, it obviously reduces the revenue for Minnesota Valley. Minnesota Valley is not Xcel Energy. It doesn't have shareholders. It has member owners, and everybody is treated the same. And in this instance, if the Upper Sioux community is allowed to co-generate in excess of 40 kW, it obviously increases the cost for everybody else.
You ever drive by Pine Bend?
I do not.
Okay, I drive by it every day up here. It's a constant source of frustration for me. Okay, I think you even cited the Pine Bend situation in the memo that you provided us. You know, I drive by it, and over the last, 5 decades, we've built lots of infrastructure for them. I, as an Xcel ratepayer, have paid for it, along with all the other large industrials. Okay, lots of infrastructure went into that to keep that facility. It's a capacity, demanding industry, just like yours is probably their biggest capacity customer, right? I'm guessing they are.
They're one of the largest, you're saying?
Yeah.
Maybe one of top 20, but they are not the largest.
Largest. Okay, so they're a big one. Okay. So I drive by that every day, looking at all that expensive infrastructure that all of us ratepayers have built. Okay? And you know what Pine Bend did? The boys from Wichita decided, you know what? As green as they are, they built which I thought was a smart move, a gas generator. Because for years, I could always tell where northeast was from Northfield, because I could just look on the horizon and I would see a big flame burning off in the distance, okay? 20 miles away. They smartened up, okay? They plugged that in to their system and put a gas generator on there, reduced their load, okay? They didn't put it back on the system. It's all behind the meter. And then they got really green, and they smartly built I think it's 48 megawatt. Mr. Zahn, you might know that facility there. I don't think Wolf River did it. I didn't see your name there when I was driving by, but I don't regulate that. Okay. They got Dakota County to say we could build it. Okay. And reduced their energy consumption. The way we do our rate case, okay, is, you know what? Now all the rest of the industrial customers in Xcel service territory are paying for all that infrastructure we put there. And all of a sudden now I have Mr. Maraska in here yelling at me saying all my industrial rates are going up, okay? Even though the bill for Pine Bend is going down. But they had the right to do that. I don't have a right to tell them what to do on their property with their behind-the-meter generation. Is that what you're saying, that I should have told Pine Bend you can't do that and that you must continue to take power from us? Is that the big fundamental argument that's in front of us today?
I have some follow-up questions for you because I am not familiar with Pine Bend. Is Pine Bend some type of a business that was purchasing power from Xcel Energy?
Yeah.
And you would agree under 216B.164, Xcel Energy is a public utility, correct?
Yeah.
You would agree that Minnesota Valley is not a public utility as defined under 216B.164, but instead is an electric cooperative association. Would you agree?
Yeah, but you're setting rates. Your board council sets rates. Your complaint that I'm hearing from you today is it's unfair.
But can I just?
It's unfair for them to co-generate behind their facility, to have power on while you are supplying their power.
I'd like to direct the commission to subdivision 3, paren A. This paragraph applies to electric associations and municipal utilities. That is why I am here. That is what Minnesota Valley's board policy is about and is consistent with. I would direct the commission to subdivision 3B. This paragraph applies to public utilities. Under this statute, Minnesota Valley
So we just had this argument. I already told you about 216B.17. Okay, you know I have the right to investigate to determine whether your standards or practices are reasonable or not. And what you're saying to me is we've set a policy, we cannot allow cogeneration. That's not allowed under. Do you have a patent on electricity? Do you own all electricity in your area? I mean, that's what it sounds like. You have this patent on electricity. And if these guys go ahead and produce some electricity behind the scene, they can't do it unless they come and ask your blessing to use it. No, you have a duty to serve. You don't have a patent on electricity. You have a duty to serve. So help me out. The one best argument I hear from you, okay, today is point 164, that somehow that supersedes this investigative authority. That's worthy to explore, okay? But I don't see that you can tell them we're going to disconnect you because you have cogeneration. That seems to fall clearly within my, whether this is reasonable policy argument. I'm struggling. So go ahead, finish. I'll let you
So you
play it out.
obviously received the 3 agreements between Minnesota Valley and the Upper Sioux community?
Again, counsel, I have, okay?
You understand that as part of that, they...
Counsel, let me be very clear, okay? This is not an interrogation of us, okay? I have seen them, and I don't know what relevance it has to me bringing a motion, okay, before this commission on our own motion to investigate an unreasonable practice that you may have against them and all the other PURPA folks. Okay? That's what I'm seeing here. So what do I care what they've signed? I have a complaint they brought for us under this statute. If you have some injunctive relief to go to district court and tell them they can't come to us, go ahead and do it. Make my day, because I don't think it's going to go very far. Okay? I have a complaint in front of me. That's what we're talking about today. So don't be bringing up agreements. I have a complaint about your policies and practices. And that might even be a policy and practice that you might want me to look at.
I would just point respectfully, Commissioner, to subdivision 11, where it specifically indicates a cooperative electric association that has adopted a resolution and rules under this subdivision is exempt from regulation by the Public Utilities Commission under this.
And
You can hear
I can't hear what Mr. Haugen said.
say it again, Mr. Haugen.
I was just referring.
Put the mic right in front of you. I'm sorry. I apologize.
I
You
was
got the bad
just
mic,
referring,
by the way.
Commissioner Sullivan, back to subdivision 11, where it specifically says a cooperative electric association that has adopted a resolution under this subdivision is exempt from regulation by the Public Utilities Commission under this section.
So can I ask a question, Commissioner Tuma? Mr. Haugen, you keep talking about 216B.164, but 216B.164 is about purchasing. It's not about self-supply. As I read the record, this is about a tribal community that wants to self-supply behind the meter. And as I listen to you and I hear you out, I quite frankly don't think you understand what behind the meter means.
What I understand behind the meter to mean, Commissioner Sullivan, is that they would be producing electricity behind Minnesota Valley's meter, some of which they would be providing through a solar array or some other source, and some of it being provided by Minnesota Valley. I would argue that 216B...
That's not, no. Behind the meter means that they're generating and consuming everything on their side of the meter. Mr. Zahn is right next to you. He can confirm that that's what that means. It does not mean Minnesota Valley certainly could be coming in and supplying additional power in front of the meter, that all of it gets consumed by the unit itself. But it means that they're not purchasing anything from you. That's the material issue that you keep saying this is says behind the meter and we have the right to stop it behind the meter. Like, I think the example that Commissioner Tuma gave is like what a customer, a consumer, a member does behind the meter, the utility can't stop them from doing that. I mean, like, you could come in and tell them, oh, we know business is bad, but you can't shut down. You can't do this. You can't put a conservation measure on your unit. Like, that behind the meter literally means it's on my side of the meter.
Right, but the argument that then you're not purchasing any power from Minnesota Valley, then why are we here if there's no risk to them if we shut the power off? I struggle with that, Commissioner Sullivan, and I'm not trying to be disrespectful.
Well, because you are still supplying them power, which, quite frankly, I think it's outrageous. Outrageous that you would say to a community that you would shut their power off. I mean, like, under what authority do you have to shut their power off? I mean, the seventh principle of a cooperative that all cooperatives abide by is to support your communities. I quite frankly, I don't understand your arguments.
Well, my argument is if Minnesota Valley does not protect its streams of revenue, it increases the cost for everybody else. And I
get that. I understand that. And I understand you're a small utility and all cooperatives are faced with that. But there is risk on your side too. And somebody may decide they're not going to use the socialized assets of the cooperative to serve their own interests. And that is just the way the cookie crumbles. There's nothing...
Commissioner Sullivan,
Sure.
The only thing is we're not telling them that they can't cogenerate. We are just telling
It sounds like you are. It sounds like you're specifically telling them that they can't cogenerate.
They can still sell it to a third party. They just can't use the power themselves in excess of 40 kW.
When I hear them say, and this is my read of the record, is that they're not planning on selling it to anybody. They're going to use it all on site for themselves.
I agree.
I mean, we could ask Mr. Rasmussen, are you going to use it all on site for your own operations?
Yes, Commissioner Sullivan, yeah, exactly right. And when the attorney for the co-op
Okay,
talks,
I mean, like, I don't mean to cut you off, Mr. Rasmussen, but, like, I am going to cut you off. Like, I don't know why we need to go much further. But, Mr. Rasmussen, I want to let you finish your point. Sorry.
the point being is that the tribe's energy consumption from the co-op has gone, over the last 20 years, has quadrupled to what it used to be. I mean, the tribe continues to expand, and it's doing better and better. So their power demands from the co-op, despite the fact that they have a 2.5 megawatt solar array, will continue to increase. So it's disingenuous to say that this is going to somehow bankrupt the co-op if we turn on a 2.5 megawatt solar array.
Exactly. Thank you, Mr. Rasmussen. I guess what I would like, it feels to me like, you know, to be fair to you, Mr. Hoggett, Commissioner Tooma, I don't want to blow up your spot. I don't know if you were done or not. So.
Oh, you keep going if you have a question. I got two other commissioners queued up right behind you though. So.
Okay. I mean, Mr. Haugen, I guess I look at this solely under 216B.17, and under 216B.17, we absolutely have jurisdiction under subdivision 6B. So I think that this is a practice. You've said you're going to shut them down. You should shut them off. And I mean, I want to come back to, like, utilities don't shut people off. If, you know, like, that's a last ditch thing. Like, that is like I question your commitment to the public if you're going to shut somebody off over turning on a solar panel behind the meter. Sure. I mean, I find that outrageous that the utility would do that.
I would agree. That
and I do want to just, I mean, so I think this is a material issue. Being fair to you, I do want to hear more why the co-op feels like it's necessary. I mean, it's 2.5 megawatts. That's a large system. But I do want to hear more from you. But my view is like, we have a material issue in dispute, very clearly in dispute. And our rules would allow for an expedited process if you both agree to an expedited process. So, I mean, my sense is that I don't know where my colleagues are, but I have a motion that is going to send this to an ALJ, that's what we do. We send things, if there's a material dispute, we send it to an ALJ for a robust development of the record. But if both of you don't want to go down that route, we can go with an expedited review, which would be basically notice and comment before the commission.
Yeah, Commissioner Sullivan, we'll
get to, I don't know if you are...
Commissioner Sullivan, we'll get to process here in a second. I do want, and I do want to cover that question, the process, and separately.
Okay.
I didn't tell you that, so that's my fault. But I do want.
Okay, that's fine.
I want to let Commissioner Hom and Commissioner Partridge. They've been wanting to get in here. I know you haven't seen that because you're.
No, that's okay. I understand. I mean, I understand. I'm still like, I think that we have a very significant material issue here, and my view is that the way we, as a commission, address, and we do have jurisdiction under 216B.17 subdivision 6B, and the way we address this is through a contested case. That's where my head is at, and we can talk about the process some more.
We'll get to that in a second. Commissioner Hom.
Sounds good.
Thank you, Commissioner Tooma. So there are some, I think, miscommunication going on between two parties. So I want to make sure that we are talking same language here. So Upper Sioux community is saying that this is a behind-the-meter generation. Min Valley Council is saying it's a cogen. Are you planning to produce heat from your generation?
I guess to the extent I understand the question, I mean, it's simply a behind-the-meter solar array used to power 30% of the power needs of the casino. That's it.
So it's not a combined power and heat generation, which is a typically term cogen is being used. That's why I want to make sure that we are talking same terminology here.
Yeah, to the extent I understand the definition of cogeneration, yes, that is correct. It's simply to power the casino, no heat generation.
Okay, so Min Valley Council, can you agree that we only talks about behind the meter generation, not cogen here?
Yes, when I'm using that term, I'm referring to two sources generating power,
Yeah.
not the thermal energy. I agree with you.
Yeah, because industry, people are using cogen in different way. Because we are in the process of developing the record, we shouldn't confuse people, particularly expert who knows what's going on. We shouldn't confuse them. So that's one thing.
I appreciate that clarification. I
Okay.
agree with that.
Thank you. The second terminology you use is a net metering. That has a very significant impact, what meaning in this industry. So I'll ask community first, and then I'll ask you. Are you planning to use a net metering, which means you sell excess capacity to the Min Valley, and then you take the service in vice versa?
No, there will be no selling to any third party. It'll only be for their consumption. And if there's excess power generated, it'll be stored in batteries. And
Okay.
I think Wolf River would probably be better to explain that than I. But
Yes, Commissioner, that's correct. It's not designed to export electricity to the system or
Okay.
to the grid. It's all going to be consumed on site.
Okay, thank you. Then the Min Valley Council, can you refrain from mentioning net metering here? We are not talking about net metering here, right?
What I meant by net metering is what they produce, what they produce, what we produce, the difference between the two of them of what they use. Yes, I will
Okay.
refrain from using net metering.
So, okay, because once again, it'll confuse a lot of experts in the record development if we are using the certain terminology in different way. Okay. So my last clarification question is, I think there is some dispute about interconnection. I understand interconnection has a two component, financial component and the reliability component. We do not want anybody being harmed by behind meter generation. That's why we are going through interconnection process for do no harm, physical harm portion. And the second component is a financial component. Whenever there is a network upgrade required by that interconnection, interconnecting party has to pay for that part. So I'll focus on that part. For the community, have you filed your request for the interconnection of your generation in this case?
once again, I think I will defer to Wolf River to answer that question.
Yes, Commissioner, that has been done, and the initial study was paid for. We received verbal comments from the engineers who conducted the study that the grid upgrades required would be very minimal and within the standard scope of any other system on the grid.
So if there is any material cost to upgrade the system to interconnect you to prevent any physical harm, are you willing to pay?
That is correct, Commissioner. That would be handled amongst the Upper Sioux community and Wolf River Electric.
Okay, thank you. Now I go to the Min Valley Council. Have you completed that process? I think it's not your privilege, but your obligation to provide that service because you are utility, which has an obligation to serve people of Minnesota, right?
I would agree.
Yes. Have you completed that function?
Are you asking specifically about has the study been completed and provided to Wolf River, or are you asking more broadly?
That is a first step, and you have to follow through from what you found from the study and make sure that they are completing their interconnection.
I believe the study has been completed. I may stand corrected, but I believe the study had been completed. I believe the study results had been provided to the Upper Sioux community and Wolf River. I will stand corrected if that's incorrect, but I believe that study had been, and it does state specifically what the cost to make those upgrades would be, which I agree with Council for Wolf River and the Upper Sioux that they've agreed to do that. And Minnesota Valley has agreed to allow that interconnection. It's just anything over 40 kW we are taking the position based on the board policy that it needs to be sold to some outside third party and not used by a member of Minnesota Valley or Upper Sioux.
Once again, that is a financial issue, not the physical issue that potentially this generation can harm your lineman or your system. So have you completed study to make sure that this new generation is not going to harm your lineman and your system when they're working in this case?
I want to answer your question. My answer is yes, and I believe with those upgrades, it would provide the safety necessary to protect both the Upper Sioux community and the employees of Minnesota Valley REC.
Okay, so I'll go back to you.
I couldn't hear Mr. Halvin's answer. Sorry, I couldn't hear his answer.
The short answer was yes.
Okay, so now I'll go to the community. Have you received that study and have you agreed to complete that physical work?
Commissioner, there seems to be some confusion here. I would just like to point out for the record that we requested an engineering study of a zero export system. That study was complete. We have never received that study, nor has it been produced to the Upper Sioux community, despite Wolf River Electric being the party to pay for that study. What happened instead was the engineers contacted Wolf River Electric and informed us that the Minnesota Valley had requested that the study be changed from a zero export system to a net metered system, exporting electricity, which is not how it's designed. But yes, since then, we have received the engineer report from the engineers for the grid impact study. It was provided to first Minnesota Valley, and then Minnesota Valley provided it to the Upper Sioux, which they have shared it with us.
Have you committed to complete the physical work on under the second study, or are you disputing that second study is not the one that you should do?
Commissioner, we're not in a position today to pick either side to make a position on that, but we are committed to performing the necessary upgrades to ensure safety in the grid.
So even on the second study?
As long as the second study is appropriate to reflect how the system truly is, then yes, we would.
Okay, thank you. So go back to the Main Valley. In that case, are you going to allow community to interconnect their generation without threatening them to disconnect the service? Because you have an obligation to interconnect them.
The board policy, which I'm here explaining to the commission, is at that point, if the system behind the meter was producing more than 40 kW, then yes, the board policy would provide currently that there would be a disconnect, as has been indicated in the letter that was provided to the Upper Sioux community.
So your concern is not about the physical harm to your lineman or your system. Your concern is a financial issue then?
I would agree generally with that assertion. Yes,
Okay.
Commissioner Ham.
So if any lawyers, I'm not a lawyer, so I cannot say that, you are violating your obligation to interconnect the behind-the-meter generation because your financial interest, then that can be a disputable issue, right?
I agree. That
Okay.
is a issue in dispute.
Okay. So I think that's the all clarification I needed, and that I'll make one comment if you allow me. Okay, your concern is a financial, right?
Primarily, yes.
Okay, so disconnecting the community will even damage more to your financial interest, because even if they interconnect 2.5 megawatt unit, they are still consuming significant amount of energy. That will bring you more revenue, right? Your baseline is 0 versus a sum. Now you are saying that 0 is better than sum.
When you look at it in that context, I would agree with you. But as I indicated, we have multiple members that would then take this position that if the commission orders or the district court orders that you have to allow interconnection of greater than 40 kW, let's say it's not just one, let's say it's the top 20 or the top 30 or just 1,000 members that all decide to co-generate. I don't want to behind the meter, and I apologize if I'm misusing terms, I mean no disrespect. But if multiple members or hundreds of members start doing that, it increases the cost. This is an area that is very rural. It is not Prior Lake. It is not Shakopee. We have 5,200 members. We have 3,700 miles of power line. And if you have the largest loads decide that we're going to co-generate compared to the Pine business that Commissioner Tuma, that will increase the cost for everybody else.
I understand co-op is a member-owned, members serving the members. So that's why the cost issue is the issue. But because of financial issue, you are potentially trying to harm, physical harm to the community. If you disconnect the service, do you agree that it can potentially physically harm people not getting electric service? Because these days, without electricity, with somebody relying on their health monitoring system with electricity, a lot of people are relying on the air conditioner when the heat wave comes, and now you are potentially threatening community with a potential physical harm for economic issue. You can dispute financial issue in separate term, but threatening to disconnect is a very different thing. Do you agree?
I agree. If I could just make one further comment, though. The Upper Sioux community it includes the casino resort. It includes the fueling station. There's other outbuildings. Minnesota Valley would only disconnect from those services that are connected to the solar array, which, as I understand, and Wolf River can correct me if I'm wrong, would be primarily for the casino resort. It would only be those services that are also receiving power behind the meter from this solar array. But to answer your question, yes, I acknowledge that if someone has a health issue and the power is turned off and they rely on that power to survive, whether that be for oxygen or whatever, I understand physical harm can occur from that. Yes. So we do not take this lightly, Commissioner Ham. I respectfully want to just relay that. This isn't something we take lightly.
In that case, how many service contracts do you have with the community? Do you have a multiple service contract or just single contract you are selectively trying to turn off?
Could you restate the question?
How many service contract do you have with the community? Do you have a one or a multiple?
It's multiple, but I cannot provide you the name or the number. I do not know.
So you have a separate feeder to feed these energy to different locations within the community?
Yes.
So you are only threatening to disconnect that in isolation that which will get the service from this solar generation.
That is correct, and that has been provided in writing to the Upper Sioux. We are not trying to do anybody's harm. I want to make clear, this is not a situation where Minnesota Valley is trying to discriminate or treat anybody poorly. As I've indicated multiple times in our letter, we want to treat everybody the same.
Okay. So one last clarification. I'm not a lawyer, but I read because my past duty. Under the Federal Energy Regulatory Commission qualifying facility discussion, your G&T basin has an obligation to take whatever qualifying facility offer that to them. Do you agree on that part?
I don't have good enough information. I don't want to dispute you. I can't confirm or deny the statement you made.
If they don't take it, you have to take it because that's the federal statute. Either you take it or you give that obligation delegated to your G&T because usually they are the one generating it. Under that, I think that you may want to check it. I checked with the Federal Energy Regulatory Commission. Under that, qualifying facility has a zero obligation to net meter. They can be just qualified as a qualifying facility, and then they got the interconnection as a qualifying facility. They don't have to net meter anything. So in this case, clearly it is a qualifying facility without exporting any energy. How can you stop that under your financial agreement with the community?
I can't comment on this federal statute that you referred. I apologize. I'm not trying to be evasive. I'm not trying to be disrespectful. I can't comment on that, and it would be purely speculative on my part. What I would point to is that as a term of service, a contract that was entered into by the Upper Sioux community in Minnesota Valley, I believe it was in 1990, they agreed to be a member of Minnesota Valley and agreed to be bound by the Articles of Organization, the bylaws, and the board policies. The board policy is why we're here today, Commissioner Ham. We are specifically enforcing the board policy, which this is what it provides. So that's what I would point to.
Thank you. I understand. That's why I'll leave that to the lawyers and the proceeding, because my understanding as a non-lawyer, I think, yes. So we do not have a dispute in this case, but I think you want to dispute. So I think so be it in that case. I'm done. Yeah.
Mr. Partridge.
Thank you, Chair Tuma. And I'm just going to ask everybody to please go through the chair. This is not a free-for-all, and we don't just argue back and forth, okay?
Even
So
though the chair sometimes argues back and forth.
that's
Thank
fair,
you, madam.
not while I'm talking. Okay, so I just want to take us up a level and say this, that from my reading, we absolutely have authority to move forward and decide if we want to investigate. And I think that what we've talked about today has shown me that I'm not sure if you're being discriminatory, but you sure are being unreasonable. I don't think that you can just pass bylaws and assert them on members if they are not consistent with policy. And so I think an investigation will determine whether that is the case or not, whether that's state policy or federal policy. I also want to just say that I think you have lost your tether to the purpose of an electric utility, whether cooperative or otherwise. You have a privilege to serve your members, not be adversarial and unreasonable to them, not inflict or threaten harm, whether that's physical or financial. I am not speaking from a legal perspective. I am speaking from the perspective of what is right. And I'll tell you a little story. I worked at a utility, and I was in a meeting with an executive and my boss. And the executive, we were talking about helping to install a certain type of technology that customers wanted. And he said, we're not doing that. And my boss laughed at him and said, it is our privilege to serve these customers. We are regulated, and in your case, I understand that you are not necessarily regulated in the same way. But he said, it is our privilege. We will do what our customers want, and we will change our business to accommodate what our customers need. That is not a legal requirement, perhaps. It is the reasonable and right thing to do, and I think you need to reconnect with the purpose and the role that you play. Instead of telling your members, gee, you're lucky we serve you, maybe you should start being more member-centered. And I also want to just say that there are a lot of cooperatives out there who are very member-centered, who are doing a great job. They must be pulling their hair out to see you here in front of us with this display. I don't need to continue to argue with Minnesota Valley. I understand if other commissioners have questions, but I think that we should just move forward to talk about what we're doing next. I am very interested in understanding the community's position on whether an expedited process would meet their needs best. I want to point out that for the community to consider, our staff has kind of penciled out what a timeline would look like for both an expedited process and for a contested case hearing. And the difference is about a 4 to 5 month process on expedited and about a 6 to 9 month process on the contested case. I don't know if you all need time to talk about that. We could take a break if the chair would have it, if you need to discuss, or we can keep moving.
Mr. Rasmussen.
Mr. Chair, Madam Commissioner, the Upper Sioux community would obviously prefer an expedited process. However, I guess we defer as an equal sovereign. I mean, this is your Public Utilities Commission, and we are an equal sovereign here, is we will respect whatever decision you make. However, there's not, I mean, the core facts are really not contested. The fact of the matter is we're putting up a 2.5 megawatt solar array behind the meter, and we're going to turn it on. That's it. And whether they have the ability under the rules that apply to them and that you guys enforce is whether they have the ability to turn off our power if we do that. I don't know what more there is to say. Whether they've done unlawful acts to some of their other members. Maybe they've told them that. From Upper Sioux's perspective, we don't really care. And we don't need to go down that road. I think they've admitted here today that the actual construction of the solar array and how it'll be connected to the casino is safe and follows whatever rules that need to be done.
Let's just run down that a little bit. And I appreciate it. Let's get into the process. And we have a rule, okay, that says that we can do an expedited process if we don't feel that there is material facts, okay? And I tend to agree with you. I'm getting pretty comfortable with maybe the facts are pretty clear, okay? But our rule says, though, that the parties need to agree. And I do view, and I think you would agree, to me the parties here, even though there are other people that have participated, are you and the cooperative. You would agree with that, Mr. Rasmussen?
Yes, I would, Mr.
And so I'm sitting here and I'm thinking we could handle this expedited process. It would require affidavits, okay, certified. I would expect your engineers to give us information, their engineers to give us information on what I think may be the only factual thing that makes me nervous, okay? Is it behind the meter? I've read Wolf River's statement from their attorney, and it seems pretty compelling, but he's not certifying as an engineer, are you? But you could probably get your engineers to do that, right?
That is correct, Commissioner.
There is still a shadow of a factual argument there. Is this behind the meter? Would you agree with that?
I guess to a minor extent. Obviously, we've been saying it's been behind the meter from day one. We've gone through an all-day mediation with the co-op and discussed that back in February all day.
You can see where I'm sitting.
I understand.
I don't want anybody.
I'm not an engineer though either.
Yeah, and I don't want anybody to get electrocuted. You know, the closest we get to it is Commissioner Hammond. His conversation. He brought us a long way to. I'm not seeing a lot of factual dispute here, but also from a legal jeopardy standpoint, you got district court actions out there. You got our actions here to protect you. You got to think about. So moving quickly is fair, but I think having a solid factual record on what behind the meter means and is, and whether that in fact is the case here, helps us all out for all of our proceedings. You would agree with that?
I would agree with that.
So it really falls now to the co-op, you've laid out what would be the factual dispute. Are you okay with doing this via? I don't know if you understand our process, but we would send out a notice saying, give us your initial comments, file your testimony. It needs to be certified. Then parties can ask each other questions, okay? And then we would have final reply comments, and then it would come back to us for a quasi-judicial process hearing here to look at the record that's laid out for us. Our staff would be working diligently to put that information together in a briefing paper. Other option is we have an ALJ, okay, who are assigned, and that ALJ will act like a judge, and we'll have a proceeding. You'll have to meet with them, lay out the scope of the hearing. They will take in the testimony almost very similar to what I just laid out, and then they will allow an actual hearing to have it happen where people can cross-examine if they want. Again, it's up to the ALJ how they handle it, and that ALJ then writes us a report. And we then have exceptions to that report that you can file, and we make a decision. As you heard the time frame, we're talking on the outwards 5 months on the informal, outward on the contested case. And again, it's up to the ALJ. They get to kind of decide, but about 9 months. We can tell them when we want to hear it, but sometimes it takes longer. Are you okay? Are you consenting to doing the informal process, or do you want a fully adjudicated ALJ process?
I don't believe delay helps anybody in this case, and I believe doing it in an expedited basis is in everybody's best interest. So Minnesota Valley has no objection to doing it in the informal way that you had proposed, Commissioner.
To the department, you are a party in our minds. I kind of left you out of there, but you are acting in the public interest, doing your public interest duties, okay? We look for you to participate. Is that your intent?
Yes, Commissioner Tuma, we do intend to participate, and in part, the department's recommendation to send this to a contested case process was based on the contents of the complaint and the comments, and it does seem today there's been maybe a narrowing of scope that parties have agreed to that the department didn't previously see in the comments and the complaint and agreement on sort of what the key issues are. I would need to confer with my client before committing them to something, but I think what we've heard here today perhaps changes our position on whether a contested
Thank
case.
our non-lawyer for kind of getting us narrow the issues, right? That's always helpful. Take the lawyers out of the room, right? Now, what I did have a decision option to do the informal, okay, and the cost question, just so you know, 216B 62, so the co-op understands, you're going to get a bill from us and you're going to get a bill from the department. I would find it very helpful, okay, that you have expert testimony. Do you feel that is valuable to you and that is something that you would hire so that we can confirm what Wolf River is saying and what, just to make sure we are talking about the same thing and we understand what the terminology means behind the meter and safely participating, you know, in the distribution system, all that stuff. I find it valuable. Would you need that, do you think?
So is this a question of expert assistance on the question of, is this a behind the meter, not metered? I believe we have that in-house. I would want to.
How about we take, everybody's kind of heard it, so I think the motion, just so you understand where it's going, and we'll have debate and discussion, obviously, when we get there, and I have other discussions to have, but I want to get this nailed down first. Would be 1, 3, and then 6, TUMA A and B, and that only for now that we're discussing. We'll talk about 8 later, okay? But that would be kind of the motion, okay? And the question to you is, do you need outside engineering help? Obviously, you're going to bill your inside engineering help if you feel comfortable with it, but I just want to make sure you're comfortable with it. I just looked at this saying, I really would like an independent analysis, and you are an independent analyzer, okay, if that's a word. So why don't we take 10 minutes?
Can I ask one question before
Absolutely.
we recess? Okay, I have a question for Minnesota Valley. I want to know if you would commit to not disconnecting the Upper Sioux community for the duration of whatever process we decide here today.
Commissioner, can I respond? Commissioner, I would like to just speak with the general managers here today, and I will give you an answer when I get back, if that's okay.
Okay, we take a recess until 22.
Test, 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 test. Can you hear it? I can't hear it. Testing, 1, 2, 3. Testing, 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 1, 2, 3. Testing, testing. Wireless 1. Testing, testing. Testing, testing. I think you can, yeah, that's picking up a little bit more. Testing, testing. Should I get a third one? I mean, testing, testing. We could move them over here. Okay. Well, this is definitely picking up. I'm sorry. Testing, testing. Testing, testing. Yeah. Testing. Testing, testing. Testing, 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 testing. I think you got it. Testing, 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 testing. Testing, testing. That's definitely better.
Mr. Hagan, we're gonna try you out on wireless mics. And that is the bad mic, and I apologize. And I talk loud usually. Yeah.
I'm unmuting everybody right now. This one right here. Okay. Very good. Thank you, sir. I appreciate it. Just remember to eat your mic.
Yes, Mary.
You know, I have you cranked up all the way, and you have a booming voice, but it's just.
It's what it is.
It is what it is. I got my sandwich. Oh, that's good. You having folks over tomorrow?
Mr. Rasmussen.
Stepmom get
It's
very
the
upset.
range, it's the range,
Yeah.
but it's not the range,
Yeah.
the physical thing.
The water would be different. Where, yeah, the water is so iron.
Don't have counsel for the tribe.
So then.
White ball. There they go.
Okay.
I just wanted, I was looking for these guys. Let's, keep going. Joe, you there? We're good. We had first a partridge question to the cooperative. You ready to answer that, Mr. Hagan?
Mr. Commissioner, I have spoken with the general manager. Consistent with board policies, if the solar array would be activated or turned on, it would be the position as previously indicated by Minnesota Valley that service would be disconnected to any services, electrical services that are connected to that solar array. But it had previously been indicated here today, and in prior communication, it's my understanding no homes or residences would be connected, but that would respectfully be the position of Minnesota Valley.
And Mr. Rasmussen, you can deal with that as you deal with it in some other venue. We have what I want to say laser focused on what we're doing, but I think that's a statement on the record that you can use however you see fit.
I'm glad to hear that. It's my understanding that the PUC does not have any kind of injunctive power. Is that correct?
That is our understanding of the law. We don't have an injunctive powers. We have powers to do things that require then to go to the OAG to make some actions. So we're a little clunky on injunctive relief, but that's the position that we're taking. We cannot order them at this stage. We can investigate and then adjudicate is the way we see it.
Thank you.
So deal with that information as you will, and I hope you will. So we have in front of us then the decision options. Department, that was the next question to you. Do you feel you need decision option 6B? Or excuse me, 6A?
Commissioner Tuma, yes, I'm glad we took the time to look into this because I was wrong. As much as our experts know and educate me on so many things, we do not, in fact, have the in-house expertise for this. So we would need to go out and get that specialized technical assistance. In this case, we'd particularly like it. Just our concern is that both parties, the co-op and the developer, have a vested interest in the findings coming out a particular way. So we think it would be helpful for the record development to just have a consultant that's coming from a neutral perspective.
Given what we just heard, I hope we can do that expeditiously.
So we will absolutely do our best. We do have our hands bound a bit by just the procedure we have to go through in terms of hiring. For an outside consultant, really, if everything is going as smoothly as possible, we are still unfortunately looking at 3 to 4 months. Given that, we do
have a pretty robust list that we developed a few years ago on community solar gardens. I would assume that a lot of those guys would be experts that could handle this. So I hope you would maybe draw on that list and try to move quickly. I don't know if they're still qualified under your contracting obligations, but
my understanding is that the procedural steps and the time each of them takes, it is still quite a drawn out process, even if the issue is not lack of qualified candidates.
Expeditious is, of course, the word, and you got to do what you got to do. We're going to try to be expeditious, obviously, on our end, too. So I am ready to move 1, 3, and 6, A and B. Is there any discussion on that? We will discuss separately some of the other ancillary motions outside of what this proceeding is. But
I believe that Ms. Arnold had something else to add.
Yes, thank you. Just having then spoken with the department about the need for an expert in the timeline for that, we were wondering, given the tone and tenor of sort of the discussion today and the information we've heard, if that timeline is going to be pushed out anyways because of the need to get that outside expert onboarded, perhaps it makes sense to have the referral to OAH, or it'll be CAH in just a few weeks here, so that discovery disputes could be dealt with through, motion practice in a venue where the ALJ assigned to that is used to those disputes and deciding that, rather than keeping it in the expedited process here.
Yeah, I looked to the parties. You heard that there is, discovery is a little more stilted in our process, the informal process, where an ALJ is going to look at it more like a judge. So I would look to the tribe first.
Yeah, I appreciate the comments from the Commerce attorneys, but that doesn't change our opinion. We'd still would recommend an expedited process.
To the co-op.
The co-op has no objection either way. I understand the concerns raised by the Attorney General's office about the ALJ. Cooperative would just defer to the commission.
I didn't hear what Mr.
Mr. Hogan is fine with the expedited proceeding. Commissioner Sullivan, do you have anything more? Or?
Yeah, I would really just prefer to go to the ALJ. I mean, I know we've talked a lot about the expedited review, but my sense is like we're trying to cobble together right now on the fly what the department need. I just heard from the department that it would take some extra months, and I hear the department now saying, well, let's go with the ALJ. I mean, I feel like this is what the ALJ is for. It's going to get dealt with appropriately. We'll get a robust record back. Everything is, it's a well-known process versus our own process, which, quite frankly, we just haven't done this very often. And, I feel much more comfortable just sending it to the ALJ, which is decision option 5.
We're in deliberation now, so so you want...
Are we in deliberations? I thought we were.
Yeah, we are. I was asking questions, but you're pushing me towards, let's resolve this now and get it done. So I'm agreeing with you. And so give me your 5 reasons for 5.
I mean, my rationale for 5 is that the ALJ process is how we go and we resolve material issues. I do think that, I think there's a high likelihood that this case is going to be litigated beyond our future decision, and we're going to get a full record out of the ALJ to base our decisions on, that, we'll all be under oath and, we'll be under the robust ALJ process. I'm not convinced that the issues really are that narrow. I don't think that the co-op is going to go back and say, okay, we just got to focus on this one thing. We've heard from him, at length today about, their issues, and I don't think they're just going to constrain that in the expedited process. So I just think we're on better footing if we just stick with the tried and true process that we have, which is probably just going to be a couple months longer. But the benefit of a couple extra months is we're going to get a more robust record. And I think that we haven't also done this before, at least not in my recollection. It's been a long time. So I think a couple months is good. I think it's a better way to, measure twice, cut once. So that's my feeling on it. And I mean, obviously I'm not going to die on this hill, but I do think it's a better, more straightforward way to deal with this, even if it is a couple extra months. I do want to say, I mean, how disappointed I am to hear that, Mr. Hogan relayed that the co-op said that they're going to disconnect. I mean, I guess I'm just flabbergasted at that, but
So let's just, on the procedure, Commissioner Sullivan, I wanted to make sure that we have a comparison, the two comparisons we're doing here. So I'm looking at, would you agree if we did 5, that maybe your 5-1 is no longer needed? It seems like we know what the venues are. We know that we have jurisdiction. It seemed pretty well laid out. So I don't know what 1 gives me. And then so that's one question I have for you. The second question, I would assume you're fine with doing 6A regardless of what procedure that we do. And the 6A is the department getting an expert.
As far as, my decision options, those are just specific things that I, at a minimum that I would expect the ALJ would cover. It's by no means like, trying to constrain the ALJ, so I was just identifying those things. In terms of venue, I was also thinking the issue of the contract in the district court. That was one of the reasons that I had put that in there.
I don't think that has any impact on us, Commissioner Sullivan. It certainly is something that Mr. Rasmussen is going to consider now, given the information he has. But what the contract is irrelevant. It's what the policy is, and whether it's reasonable or unreasonable. And I think that's the focus. I don't need the ALJ to talk about the contracts. I need them to talk about what is our jurisdiction, the reasonableness of this policy. That's what I'm worried about. One is kind of opening it up and having them talk a little too broadly on areas that I don't need information on.
Sure. I mean, and if you're more comfortable removing 1, I can be fine with that. From my perspective, points 2 and 3 are, more important in my mind. And again, like I don't think of this list as like this is the exclusive list of questions that we want the ALJ to focus on. I think the ALJ is going to focus on and develop the record in their own way through the parties, comments, and so, I'm comfortable if you want to remove 1, maybe they'll get to it anyways, but
that's helpful. I think that gives us a clarity of we have 2 options in front of us, and I like to keep it narrow to our jurisdiction. So, Commissioner Hom.
Thank you, Commissioner Tuma. So my preference is not going either, because this is more the food for thought for the Min Valley Co-op board members and your managers. I was at the data center conference last 3 days. I think nowadays, this industry, the most scarce thing is capacity and energy. Everybody's scrambling to find more capacity and energy. Rather than you fight with your member owned, actually you're fighting with your own owner. Change the thought a little bit in different angle, trying to find a way to use this as a leverage to find more revenue for the co-op members. So not only they are doing their own generation, but you can use that your obligation from the basin as your leverage to sell those obligations to somebody else to make a profit out of it. This process will cost you a lot of money. As I think we already mentioned that there'll be a charge to you guys under our system. Not only you will incur that cost, but also you are missing out huge potential. You can invite data center to your service area, that's 1. 2 is, even if they don't show up, you have excess capacity and energy from these behind-the-meter generation. You can sell at the premium. I don't know whether you are aware, but yesterday, PJM, which is not a MISO, but our neighbor in the east, just cleared the capacity market at $329 per megawatt day, which is a lot higher than building CT unit. So everybody's scrambling to find the capacity and energy. That's why if you are only worried about financial issue, I hope you can find a better path than going into this dispute rather than you going through that route. Take this offer, do it, find different business opportunity. I hope that helps, but I can support either motion, but I think my preference is co-op understand this is not a challenge to you, but this is your opportunity to make more money.
So you're leaning towards the expedited is what I'm hearing.
Yeah.
Commissioner Partridge, sorry to put you in the pickle in the middle, but your thoughts?
Thank you. Chair Tuma, I would request 5 minutes. I am very displeased with the answer I was given about disconnecting the tribe, and so I think that that may escalate this for me to a different type of action. I see representatives from the Office of the Attorney General, and I believe they may be able to take some action in this matter, but I want to confer, if I can, for 5 minutes with our staff.
Yep, we'll take recess until noon. Don't go far.
Testing, testing, testing. Is it louder? Testing. This one? This one? Testing, testing. I mean, this one's like even being right here. This one?
Get back in to go. Mr. Haugen, thank you for continuing to move around the mics. We apologize for the mic situation. Are we ready? Joe, can you hear us okay? Excellent. We are still in deliberation on the motion. Commissioner Partridge.
Thank
thoughts.
you. Chair Tuma, I worked with staff on a proposed additional decision option. It would not be removing any of the decision options that are currently being discussed. This would be a separate process. So it is of my opinion that what we have heard today and what is on the record is that we will likely or potentially see, we are likely to see, a violation of Chapter 216B, and that is about to occur based on what was said today. Therefore, I would like to refer the matter to the Office of the Attorney General to take appropriate legal action on behalf of the public interest to intervene in whatever the most appropriate way may be based on their legal expertise. I am not a lawyer, but I hope that the Office of the Attorney General will consider some sort of injunctive relief to ensure that a disconnection does not happen. This is something that, as we've talked about, the Commission doesn't have the power to do, but we do have the power in 216B.54 to refer this to the Office of the Attorney General and to request that they take legal action.
Would you like to hear from the department or OAG on your motion?
I am getting head nods from Ms. Henderly.
Ms. Hinderly, why don't you come over here by Mr. Rasmussen? Don't go to that mic. It's been acting up today.
Thank you,
Ms.
Chair.
Hinderly, state your name for the record and who you represent.
Thank you, Chair Tuma. Catherine Hinderly on behalf of the Office of the Attorney General.
Your thoughts?
We are, of course, we always stand ready to take referrals from the Commission if it, is of the opinion that there will be a violation of any item in 216B. I do note that 216B.54 also allows the department to refer the action. So another option would be if the cooperative is potentially rethinking their statements today, the department could make the referral later if they were entrusted by the Commission to do that.
Ms. Arnold.
Commissioner Tuma, we're in agreement during the break. We were taking a look at the statutes and came to the same conclusion that the co-op is obligated to provide service, and if they are not doing so, or if they are about to do anything that would violate their obligations to provide service, either the PUC or the department can make the referral to OAG, which can then take the matter to district court.
This is a direct referral. Like, obviously, you have to manage a decision about whether to go, so I would assume there would be discussions with the cooperative, even if we do number 10. Is that correct?
Chair Tuma, absolutely.
I am comfortable. I will add it to my my decision option.
Thank you.
All those in favor of the decision, Commissioner Sullivan, my apologies.
Okay, two things. One, I want to make sure that I know what the motion is that we're voting on. And then two, I had an addition that I wanted to make to, let's go over the motion first.
I was going to move based on what I understood from Commissioner Partridge, but I could have made an assumption wrong that she was for the expedited proceeding, and so I should ask that first.
Yeah, thank you, Chair Tuma. So in raising this additional decision option, which could, and I am not a lawyer, but I hope provide injunctive relief and not allow the cooperative to disconnect the community. In that case, it would provide us additional time. And so I am comfortable with whatever direction other commissioners would like to go with in terms of whether it's a contested case hearing or expedited. I did just want to mention that my intent with this is that it would forbid hopefully there will be legal action to forbid the cooperative from moving forward, and that could allow for additional time for any kind of discovery in a contested case proceeding. However, I'm not taking a strong stance on that. I just wanted to add that. But
So we got two people that are not strong, Joe. It's between you and me. What's your feelings? You had an addition.
Well, I mean, I like what Commissioner Partridge has brought forward. I wanted to add one other thing to the decision option that I had for new Sullivan decision option 5. And I was really disturbed that they had said that, and I think that Commissioner Partridge has very thoughtfully put together a response. I think that action is deeply out of sync with what a utility should be doing in the service of the obligations that it has under the state service territory laws. Those, we as a commission determine what the state service territory laws are. That's core and central to what we do, as you know, Commissioner Tuma. So what I was thinking about adding to my decision option, and I would add it to decision option 2, which we would have the ALJ brief us on, or would have the ALJ brief, would be under decision option 2, it currently reads, what is the appropriate remedy for resolving this dispute? And I would specify including adjustment to the cooperative service territory to allow another provider to serve the Upper Sioux.
Commissioner Sullivan,
and this would be, as far as I can tell, this would be novel, this would be new, but I would very much like to hear, what the ALJ would have to say, since this is in the remedies section, and since I don't believe any utility should tell their customers and the people that they serve that they would disconnect them without due process. I'd like to brief this question.
Commissioner Sullivan, I'm going to have staff put up on the screen the statute on service territory, and so I don't think I need to be briefed on it at all, to be honest with you. The statute's very clear. Back in '74, we set the service boundary territories under certain conditions. I kind of brought this up with Mr. Rasmussen in 1974. We probably did not have the same view of tribal sovereignty that we have today. There's been a lot of cases that have happened since that time, and you know probably better than most about those cases, and so I think there has been a lot changed. When I looked at the statute, I thought it was going to limit me to already served, whatever. But I look at Minnesota Statute 216B.39 subdivision 3, and of course emphasis added. It goes through all the different things that I was supposed to follow we were supposed to follow when we set the territories. But then it has specifically subdivision 4. Provided further that at any time after April 12th, 1974, the commission may on its own, okay?
Yep.
Specifically, very clear, make changes to the boundaries of the assigned service area. So I think we have jurisdiction to do this, and what I was going to suggest to council after we finish the motion on this complaint, okay, specifically the interconnection question, is whether, and I would think they would want to take it back to their council, and maybe Xcel, you paying attention back there, Al? Okay. Maybe Xcel might have a different attitude if their regulators would say, you know what, we're kind of interested in whether we should re-examine our decision of 1974 on what the service territory is for the tribe. I don't know what consultations they've had with Xcel. You're kind of on the end of their distribution line there too, so obviously there would have to be some cost to interconnect a bigger load like this. But maybe that's a separate parallel discussion that we can have after some consultation. Ms. McKinley and those can go and have some consultation and see what their feelings are. I think that's a power we have already. I don't need the ALJ to tell me whether I have it or not, or make a determination on it. I want her to focus, him or her, to focus narrowly on this question. And so I would say to you, Commissioner Sullivan, let's hold off on that. But say to the tribe and to the community that we're taking this seriously, and one of our options may be to bring on our own motion a change to the service territory area. And so that's what I would suggest. And I hope I think you'd be open to that, because I don't need the ALJ to tell me whether I have that authority or not. I have it. And by the way, I'm also considering that for Skybo, by the way, so.
I mean, I think we've had the conversation. Let people know, like, this is what
So with that, Madam,
we're thinking
I'm
of.
the chair. I was going to say Madam Chair.
I mean, I still would say, Commissioner Tuma, after hearing the discussion, I still would feel more comfortable with an ALJ process. Like I said before, like, if you're like, no, we got to go informal. I mean, I can get my head there, but I do think just, it's a belt and suspenders approach, tried and true.
Yeah, I'm comfortable with Commissioner Sullivan. I feel that it's important that that's what makes you, I understand the importance of having that thorough record. I just didn't want to dive into a separate issue that I think we can handle separately and parallelly. So I'm of the opinion that the motion I would make to Madam Chair, if she was here, to you all, now that I'm the chair, would be 1, 3, 5. Okay. Your 5, 2, and 3, okay, as they are, the addition, okay, and then the 6A, which is the expert going forward. And certainly with that, just to close it up, I am open to the tribe having consultations with Ms. McKinley.
I'm assuming
about service.
Commissioner Tuma, I'm sorry, I blanked out there, but I'm assuming, you said Commissioner Partridge's decision option 10, right?
If I didn't say, I mean to say Commissioner Partridge.
Okay.
Thank you for yes. And so with that, though, I do think there is conversations that can be had. I do not take 8 lightly. I'm not putting it in here because I want to stay laser focused on the dispute, the quasi-judicial dispute in front of us. There's some policy decisions to be made. We have been talking about it internally, about what the policy looks like or should look like, but it is very different for everybody else. And how that looks for White Earth or Red Lake and, Prairie Island, all different. So we should have a thorough discussion. And to those parties that have brought that forward, we are open to that discussion, whether it be a planning meeting, establishing a rules process, establishing a policy. We're open to what would seem to be the best. At least this one commissioner is, and I would be shocked if any of my other commissioners would not be. So, and we are open to the concept of specifically for this tribe, a discussion of their right to a service territory change pursuant to the Minnesota statutes dealing with service territory area. And so when we take that sovereignty question very seriously. So I just want to make sure that is clear. With that, unless there's any further stuff, Commissioner Partridge.
Thank you, Chair Tuma. I just have a question about your perspective on how we would consider a change to service territory, if not through the ALJ report, because it does seem like that is, I appreciated that amendment, and it seems like that could be an appropriate consideration given what we've heard today.
I think it may be an appropriate solution to the overall bigger problem, but I'm trying to stay laser focused on the dispute that's in front of us and brought to us.
Okay.
I do see service territory change as a possibility, and I have authority to do that. I don't need to ask an ALJ to look at that. We can do that by notice and comment pretty easily.
Okay.
And I think that's something we could consider. I would not want to do it, though, just off of me thinking it's a good idea. I would rather the tribe explore that and have that discussion internally, and I'm not just dropping it on them as a possible option.
Sure.
I really do want that to be a consultation, and that can happen before it's a party issue, okay?
Okay.
And so Ms. McKinley knows the rules on this. She's going to do her best to make sure we have open conversations. It may be a solution they discuss, okay, and can come up with in the settlement. I don't care. We do encourage settlement here, okay, and that's something we would hope that there would be cooler heads prevail and there would be settlement discussions. But that's my thinking on it, Commissioner Partridge, is that let's focus on the dispute that's in front of us. And maybe there's another solution that we would consider, and I would consider definitely on my own motion. I think that statute is very clear on what I can do at this stage.
Okay.
It's, and I don't need an ALJ to talk to me about it. You know, I love maps, so.
Okay.
So with that, any further discussion? Seeing none. Well, we have to take a vote. Commissioner Partridge.
I'm ready to vote.
To a motion.
Oh, yes. I approve. I accept.
Yes.
I support.
Commissioner Hahn.
Yes.
Commissioner Sullivan.
Yes.
I also vote yes. Thank you for your participation. Not a lot of fun, but we appreciate the hard work everybody's put into it. We are going to take a recess until 1:15. So I apologize for all those who've been waiting for it, but we need to take a break. For those who are on the next docket, please come right to the table, find your chair, so that we can get right to it so we don't have a lot of delay. I don't want to do the old awkward where do you sit thing. So, and Ms. Arnold? You okay? With that, we are standing in recess until 1:15. just about to start, Joe. Audrey forgot her iPad, so. Joe, we're just about to start. Audrey forgot her iPad, so she's running back to get it. So we'll take off here and we'll see how fast she can run. She claims she's a runner, so probably time her. Yes, she did. You know, and if the department would let her use her shower, she would really love you forever, by the way. So. Just a hint, you know. And I won't make you. Just making a point. Well, they did, but they didn't listen. So, and Audrey wasn't on when we were doing that either. So that would we'll tell you later. Okay, we're back in. We had notice go out on oral discussions. Everybody has how much time, Ms. Twilliger?
2 minutes.
2 minutes.
Do you want me to introduce the item first?
I just wanted to make sure everybody knew we got an order, and now you can introduce the item, Ms. Twilliger.
Great. Thank you, Chair Tuma and Commissioners. Item number 2 today is docket number E002 CI-24-318 in the matter of a commission inquiry into a framework for proactive distribution grid upgrades and cost allocation for Xcel Energy. Since the close of the since staff briefing papers were filed, there were a number of documents filed into the record. Parties filed their preferred decision options, which staff compiled and posted to the docket as the staff compiled decision options and draft framework. Staff also posted a matrix of positions on the numerous subsections of the draft framework. Commissioner Hom also offered 3 modified subsections and his preferred decision options. There are copies up at the front if anyone doesn't have that. That was also filed to eDockets and is available. And beyond that, that should cover the various documents that were filed. I also just want to take a moment to say thank you to all the work group members. This was a 9-month process, and it wouldn't have been possible without everyone's hard work and dedication. So I just wanted to take a minute to thank folks for sitting through this long process. And now I will turn it back over to you. Thank you.
Thank you, Ms. Twilliger. Just so everybody knows, we have the compiled decision options she just mentioned. The top is July 22nd, 2025. That will be our working document today, so you make references to a decision option, whatever. Hopefully everything's compiled in there and just point us to it. So even if it's your decision option, say on page 7 of the compiled decision options is that what I'm talking about. And then when we get to the decision, I think it's just going to be simplest to be working from Commissioner Hom's motion. So that's kind of my thinking on how the process goes. And so with that, we have Xcel Energy, Mr. Munson.
Thank you. My name is Brian Munson, representing Xcel Energy. Good morning, Chair Tuma and Commissioners. Thank you for the opportunity to speak today. We appreciate staff's work on what has turned out to be a complex effort, especially on a very tight timeline. At its core, this framework is about regulatory efficiency and speed, designing a framework that facilitates the desired investments in the desired time frame that will achieve Minnesota's policy objectives. We're excited about the framework's potential to help prepare and advance the distribution system to more readily support those policies such as beneficial electrification and increased distributed resources. To unlock this potential, however, the framework must be constructive, practicable, and as simple and clear as possible. Some of the framework components are detailed and nuanced, and seemingly small variations between alternatives could lead to significant operational or economic impacts. An overly complicated or unclear framework, especially regarding cost recovery, risks undermining regulatory efficiency and discouraging the necessary investments to transform the grid. Now we'll go through our positions on the disputed items in Decision Option 4 of the proposed motion. Starting with Section C, we support Xcel C6 over HOM Xcel C6. In Section G, we have concerns about but are willing to accept staff G6. In section J, we support JE over JD. We oppose J10 and J11 and are also unclear on what the exclusion of J12 from the framework would mean for how the cap would be implemented. We support J14 over J13 and also prefer ATE J19 over staff J18. And last, in section M, we have concerns about M12 and would prefer Xcel M12 instead. Thank you, and we're available to answer your questions.
Excellent. For those of you online, turn your cameras on. Next, I have Alliance for Transportation Electrification, Ms. Turnbull.
Thank you, Chair Tuma and Commissioners. My name is Elizabeth Turnbull, and I'm speaking on behalf of the Alliance for Transportation Electrification, or ATE. We are a 501c6 nonprofit corporation made up of utilities, automakers, EV charging hardware and software vendors, and other interested parties. We are active on the question of proactive distribution grid planning and investment in several states, including New York, California, Colorado, Massachusetts, and of course, Minnesota. We really appreciate the stakeholder process that has unfolded to develop a draft framework, and we are in agreement with most of Commissioner Ham's decision options, so my comments today focus on points of difference. We believe that the goal of a proactive framework should be to enable a utility to plan proactively and invest in the grid to serve the timely need of customers. We believe that robust planning, sophisticated load forecasting, and upfront stakeholder engagement can minimize risk substantially while maximizing benefits. To that end, we support certain sections in the framework that enable utility investments in proactive upgrades on par with other utility capital investments. This includes allowing a rate of return on the investments by applying cost share fees to offset the overall revenue requirement of these capital investments. It also includes not capping proactive investments at any specific dollar amount or percentage, as this would place an artificial ceiling on investments that the utility might otherwise be able to demonstrate are needed. Lastly, it includes establishing an advanced determination of prudency for approved proactive investments. Most of the information on the need, scope, and costs of proactive projects will be vetted rigorously ahead of time between the utility, commission staff, and stakeholders. These factors, along with some others like robust information sharing and risk mitigation measures, fulfill the key principles of a traditional backward-looking prudency test. Thank you for the opportunity to participate in this process. We commend the commissioners and staff for their leadership on this issue, and we look forward to further engaging with you and stakeholders in implementing the framework.
Thank you, Ms. Turnbull. Next, we have the American Council for an Energy Efficient Economy. Ms. Ghosh, please proceed.
Hello. Can everyone hear me?
Really well.
Thank you. Good afternoon. My name is Zaivi Ghosh, and I am a Senior Transportation Research Analyst with the American Council for an Energy Efficient Economy, or ACEEE. ACEEE is an independent nonprofit organization dedicated to advancing energy efficiency policies, programs, technologies, and behaviors. Thank you for the opportunity today to provide a statement on the inquiry into a framework for proactive distribution grid upgrades. ACEEE does not have any significant disagreements from the preferred decision option proposed by Commissioner Ham today. ACEEE supports the establishment of both the proactive grid upgrade framework as outlined, as well as the development and initiation of phase 2 of the proactive grid upgrade work group to address any remaining concerns and improve upon the process. Regarding Section K on cost allocation, we urge the Commission to reconsider the exclusion of the Subpart K26 alternative proposed by the Office of Attorney General's Residential Utilities Division and include this alternative for K26 in the final framework. According to Minnesota Commerce Department's 2024 Energy Policy and Conservation Quadrennial Report, low-income households in Minnesota have a median energy burden of 9%, which exceeds ACEE's 6% threshold for high energy burden, as cited in the same report. Inclusion of subparts K26 alternative would help manage the impact of cost increases from upgrades, if any, on under-resourced customers and ensure that all customers, regardless of the economic status, can benefit from the proactive grid upgrades. Thank you again for the chance to speak today.
Thank you so much. Mr. Damian from SEAM.
Good morning, Chair and Commissioners. My name is George Damian, representing Clean Energy Economy Minnesota, also known as SEAM. SEAM is an industry-led, nonpartisan, nonprofit organization representing the business voice of clean energy and energy efficiency in Minnesota. I have a couple of points to make before commenting on Commissioner Ham's proposed decision options. And again, I want to thank all the stakeholders and staff for their great work over these last 9 months in this process. The intent of this law is to giving rise to the proactive framework work group. Decision options before you is to change business as usual to a more efficient and economically managed transition of the distributed energy system. Minnesota has aggressive, firm, renewable energy requirements between now and 2040, and Minnesota has much more distributed energy resource potential, dozens of gigawatts. That renewable potential, however, must be met with a modern grid. SEAM's decision options speak for themselves, but I'd like to highlight 2 quick points. First, to ensure the proactive framework yields desired outcomes, we respectfully request the Commission support decision options C11 and C11A through F to involve stakeholders in the process going forward. Second, given the number and types of proactive issues requiring engagement of stakeholders and further decisions evaluation, if those decision options are not adopted, they could be moved to Phase 2, and that Phase 2 is taken up rapidly. And while at this time we have no significant issues with decision options offered by Commissioner Hom, we do have questions about the reference to substantial impacts and capital cost in C6 and just what is meant by that. Thank you again for your time, and we'll be around.
Jamie, thank you so much. Mr. Bowman, introduce yourself for the record, and I'll let you state the name of your coalition because it looks like a mouthful there. So.
Yes, thank you, Chair Tuma, staff. Thank you for the opportunity to speak today. My name is Nick Bowman, and I represent the Coalition for Community Solar Access, or CCSA. We are a national trade association representing more than 120 member companies working to expand consumer choice and access to solar for all American households and businesses through community solar. We support the Commission establishing a proactive distribution upgrade framework for Xcel Energy. This is an essential step away from today's reactive approach, which too often results in high interconnection costs, lengthy delays, and a piecemeal grid upgrade process that slows down deployment of distributed energy resources, including community solar. CCSA supports key elements of the draft framework, including robust forecasting and site prioritization, transparent filing requirements and evaluation criteria, ongoing inclusive stakeholder engagement, regular detailed reporting, and a commitment to Phase 2 of the working group that incorporates DER demand assessment, cost allocation for multi-beneficiary paid projects, flexible interconnection options, and equitable capacity reservation policies to ensure proactive upgrades fully support Minnesota's distributed generation goals. These components are critical for enabling community solar to continue delivering value to Minnesota consumers and the electric grid. Without proactive planning that accounts for front-of-the-meter projects, the state risks leaving untapped opportunities for cost-effective, community-driven, clean energy on the table. CCSA urges the Commission to adopt the draft framework and implement Phase 2 as soon as possible to ensure that proactive planning is inclusive of all DERs. Thank you for your time and leadership on this important issue. I look forward to continuing to work with the Commission and stakeholders to make this framework a success.
Thank you, Mr. Mohlman.
Thank you.
Ms. McConnell, state your name for the record and who you represent.
Thank you, Chair Tuma, Commissioners. I am Erica McConnell here on behalf of the Environmental Law and Policy Center, as well as Vote Solar and Cooperative Energy Futures, with whom we commented jointly in this proceeding. Thanks for the opportunity to speak. Our organizations view this framework as an important step towards achieving state policy goals related to distributed energy resources and electrification. It helps ensure that the grid is not a barrier to adopting DERs and electrifying, especially for residential and small commercial customers. This is a core goal for our organizations. While we recognize that proactive investments come with increased risk, we believe the framework can mitigate these risks while realizing the benefits of increasing adoption speed, avoiding supply bottlenecks, and improving efficiency. Our preferred decision options and framework provisions are almost entirely aligned with what Commissioner Hum has proposed. Although we diverge in a few places, they're mostly where we didn't oppose an alternative that the commissioner chose over one we supported, or else on issues that we didn't have strong opposition. The one thing I'd like to flag is the exclusion of J12, which is a provision that we support. It would have project costs no longer count against the total cost cap once a project's cost share window is closed. We continue to support the establishment of a cost cap under J10, but are concerned that without J12, such a cap could close the door to otherwise qualified and beneficial proactive upgrades in the future. Beyond that, in sum, I'd say we're comfortable with the direction Commissioner Hum has laid out. On the Commissioner's new framework provisions, our organizations are not opposed to Hum Xcel C6 and Hum JB and can support Hum JI. Like the Commissioner, we also support decision option Xcel 8. I look forward to answering any questions you may have. Thank you.
Thank you, Ms. McConnell. Mr. Mulhern for Fresh Energy. State your name and...
Thank you, Chair Tuma and Commissioners. My name is Will Mulhern. I'm the Director of Electricity at Fresh Energy, and I'm representing Fresh Energy today. I'll keep my comments brief. Fresh Energy appreciated the opportunity to participate in the Proactive Grid Upgrades Working Group, and we're very pleased with the draft framework resulting from that process. We largely support Commissioner Hum's proposed decision options, so I'll just focus on a few additional items from the framework that we would like to see included in decision option 4. Fresh Energy supports Xcel's proposal for capacity reservations as outlined in L.4 and L.4a in the draft framework, and would like to see those included in Phase 1. We believe allowing small DERs to exceed the planning limit is a reasonable way to reserve capacity for these projects without limiting access for larger projects. We support further discussion of capacity reservations in Phase 2, but believe adopting this approach in Phase 1 will help ensure capacity created by Xcel's initial proactive upgrades is reserved for small DERs. We also support the inclusion of K26 or the Department and OAG alternative to support the mitigation of adverse bill impacts on under-resourced customers. That's all I have today. I appreciate your time, and I'll be available to answer any questions. Thank you.
Mr. Mulhern. Shay Banton from IRAC. State your name for the record and who you represent.
Hi, good afternoon, and thank you so much for the opportunity to participate. My name is Shay Banton, and I'm representing the Interstate Renewable Energy Council, a 501(c) nonprofit that advocates for the rapid adoption of clean energy efficiency to benefit people, the economy, and the planet. IRAC supports much of the draft proactive upgrade framework. However, we remain concerned about two key deficiencies that we urge the Commission to address in the second phase of this working group. First is in alignment with equitable outcomes. There needs to be a clear process for when per kilowatt upgrade costs are too high. As we all know, community-led and owned projects often have lower financial risk thresholds than others, and thus may be disproportionately impacted by per kilowatt upgrade charges. This concern mirrors findings in the reactive upgrade working group, sister to this group, where the capacity and tolerance for upgrade costs clearly differed between developer types. So to avoid penalizing many of the projects this framework seeks to support, Phase 2 should then support additional equity-focused strategies under such conditions. Second, the need for an advanced cost allocation methodology. As noted by several of the working group members here, the current framework lacks a defined structure for allocating upgrade cost. This is due in part to disagreements on whether cost responsibility should be based on upgrade causation or realized benefits. IREC strongly supports shifting towards a benefit-based cost allocation model. That's decision option 815, which better aligns with the state's clean energy goals. To this end, we submitted a potential methodology in our earlier reply comments for consideration, and we encourage continued technical discussion in Phase 2 to evaluate the full range of viable cost allocation strategies. And for these reasons, IREC supports the continuation of this working group. Thank you so much for the opportunity.
Thank you. Mr. Zahn, do you have something to say? That would be a wise decision.
I'll be very brief, and I'm sure the Commission will appreciate that. Curtis Zahn on behalf of MNCEA. All I wanted to say is we really appreciate participating in the work group and wanted to commend staff for both the excellent briefing papers and obviously all the work that was done. Briefing papers obviously summarize our positions, and so we're here for any questions. Thank you.
Excellent. Thank you, Mr. Zahn. Next, we have Sam Houston. State your name and who you represent, Ms. Houston. I see your name there, but I'm not seeing you on the camera. Miss Houston. Space calling Houston. We have a problem. Circle back. I've been told by Hannah to circle back to you, Miss Houston, so once we figure out the technology here. We will do that. So I guess we'll go to Mr. Schultz.
Good afternoon, Mr. Chair and Commissioners. Peter Schultz for the Office of the Attorney General, Residential Utilities Division. I want to echo the thanks for staff's hard work in the briefing papers and for leading the process, which I think really went efficiently, and thank Commissioner Hom for putting forward a proposal for consideration here. Proactive distribution upgrades are a new model in Minnesota, obviously, and that carries both risks and opportunities. Overall, the OAG supports the direction, establishing a framework in line with Commissioner Hom's proposal. However, we think the Commission could do a bit more to protect Xcel's residential and small business customers from subsidizing upgrades made to serve large commercial enterprises like fast charging stations, commercial fleets, or data centers. So I'll focus my remarks on two issues. The first is defining what projects are eligible for the proactive process, and the second relates to cost allocation. The Commission should exclude from the proactive process upgrades that are made with a specific customer in mind. The Commission can do this by adopting OAG B16 instead of staff B16. We don't think that making upgrades for a single customer is the purpose of this framework. And so instead of going through the proactive process, if Xcel has a specific customer they're expecting the need to go up, or they're expecting a customer to locate in a certain point in the future, Xcel should work directly with that customer to ensure that its needs are met in a timely manner, and the customer should be charged a kayak consistent with current policies. And also note that OAG B16 is consistent with another decision option, K22, and those could be adopted either together or individually. And then the second issue I wanted to address is that the Commission should protect residents and small businesses from subsidizing upgrades that serve large commercial and industrial loads through the cost allocation process in the framework. And the Commission can do that by adopting K24 and OAG Department K25 instead of K26, or sorry, instead of K6. We acknowledge that this approach differs from how distribution upgrades are traditionally allocated, but proactive upgrades are not traditional upgrades. They're an attempt to anticipate loads that may or may not materialize at some future date. And moreover, the proactive framework already departs from traditional cost allocation principles by eliminating kayak. So allocating costs as proposed by K24 and OAG Department K25 would better reflect cost causation than K6 and would help protect Xcel's most vulnerable customers from the risks and burdens of proactive upgrades. That concludes my remarks, and I'm available for questions.
Thank you, Mr. Schultz. I think I see Ms. Houston on. Can you hear us? Go ahead.
Thank you so much, and my sincere apologies for the technical difficulty. Actually, not my first webinar today to have my Wi-Fi dropped out, so sincere apologies there. My audio is separately connected, so if my image drops out, I should still remain with you. With that out of the way, let me say hello. My name is Sam Houston, and I'm here with the Union of Concerned Scientists, and really appreciate the chance to be with you discussing proactive grid upgrades today. I think other stakeholders have commented on how important this is to evolve the paradigm for grid investments to meet our clean energy and other power sector goals. And so to that end, I would say this framework that you have before you is a great example, not only in the product, but also in the process. So on that process and product point, let me thank the commissioners for initiating this, to my fellow stakeholders for the really productive discussion, and to staff, in particular Ms. Terwilliger, for the really excellent leadership and really excellent briefing materials that I had a lot of fun with, using quite a few colored pens, cross-referencing everything. I would say UCS supports Commissioner Ham's proposed motion. We wholeheartedly support many of the items therein, and on the handful of others, we either do not oppose or take no position, and so we're prepared to support that motion. I do want to draw your attention to just a few things within that. First of all, I really appreciate under Section A tying this framework to the achievement of state goals. UCS would have supported a stronger tie to that. I think we can all agree the amount of grid upgrades we need to meet goals is non-zero. However, we do not oppose A2 and just want to underscore the importance of state goals and the importance of the framework to that. Secondly, I want to also comment on B16, which was just raised. We support staff B16 as selected in Commissioner Ham's motion, and we appreciate the spirit of what the Attorney General's office is trying to do there, but we have a concern about sort of a wholesale prohibition against upgrades that are associated with an identifiable customer. We think that might undermine some of the stakeholder input that we would like to see as the forecasts are developed. We think specific customers saying, yes, we're likely to do this, or have you looked at this location, actually improves those forecasts and reduces risk. And so I think we would like to see other ways to avoid, sort of the risks that are behind the spirit of that decision option, and underscore our support for staff B16. And then finally, I just want to also put a line under that stakeholder engagement. I mentioned it in the context of B16, and I believe that C10, with all parts included, will help us have that kind of robust stakeholder engagement with dialogue with Xcel and accountability to what those stakeholders provided to improve the forecast and the overall process of making proactive upgrades, the demand for which we can be more certain will materialize when we have that kind of feedback, as well as cultivating trust and transparency. So I will leave it there for now and would welcome your questions. And let me say thanks again and sincerely sorry that I missed my first time around.
No problems, Ms. Husen. And finally, Dr. Lieb.
Thank you, Chair Tuma. Thanks to the Commission staff for convening the work groups and providing a high level of organization throughout the management of the draft framework and all of its components. We appreciate Commissioner Ham for a proposed motion for consideration ahead of the meeting. There's a few areas we'd like to highlight in the Ham motion where we either have a small disagreement or where something was chosen that was not with our original supported, but we can support the Ham alternative. First, on cost allocation, this was one of the leaner sections of the framework until the end, and the department notes that advanced cost allocation principles and cost recovery methodologies are going to be a topic for Phase 2, and that's supported in Commissioner Ham's motion. We're comfortable moving forward with the level of consensus formed in the work group and supported by Commissioner Ham's motion, which are framework components staff K2 through K6. On the cost-sharing window, the department supported a longer window to capture a full or near full asset life, but we appreciate Commissioner Ham's proposal for 10 years, and we're not opposed to the Ham JB. On the proposal for non-specific proactive measures, which is Section 8 of the draft framework, the department supported removing Section H to Phase 2 of the proposal because this section was less developed than many of the other sections in the draft. However, if the Commission believes there's enough flexibility upon potentially receiving a proposal under this section to iterate on the review, or as mentioned in the staff briefing papers, simply deny an incomplete proposal, the department could be comfortable supporting staff H3. Having an example to work with might be helpful in building out the section. We also support new Xcel 8, which regards proposed tariff pages to implement the relevant portions of the framework and supports a Commission-ordered comment period and hearing on that issue. And then finally, we continue to support decision options 9 and 10. 9, which is because as stated in our comments, if a utility expects a large system growth, there's a clear benefit to size the system to meet longer-term growth expectations to avoid repetitive upgrades. The voluntary nature of the framework will not require the utility to evaluate its system for proactive upgrades and provide its analysis to the Commission and stakeholders. And we've identified that there's a risk to ratepayers here that we're attempting to mitigate, as utilities can earn a higher return on equity if assets are replaced redundantly. And this reporting requirement would require utilities to identify opportunities for potential cost savings. Finally, we're supporting 10 because the department believes there's an overlap between proactive and reactive processes. Uncertain load forecasts are an input to the load seer, which propagates this uncertainty to an even more uncertain geospatial load forecast. And these forecasts are a poor substitute for known customers. Given the potential forecast uncertainty, the proactive process should supplement rather than supplant the reactive process. The department's available for questions.
Commissioner Hom, where would you like to take us?
Thank you, Commissioner Tuma. So I'll make a brief comment first before I ask questions. So I think I try to be a mediator on this one. I think this is a workflow process. So probably you may not get what you want, but I think we have to live with it. When I was doing this, I closely follow our staff's recommendation, and then plus my goal of making sure that this is a good thing, we need to move quick. So I think I really appreciate Xcel had that opening statement that you agree with that statement that, yes, this is a good thing, but we need to move quick. Yes. Under that framework, I try to create something in the middle ground. So yeah, that's why I hear that, yeah, you agree with me, but you have some exceptions. So, okay. So let's start with Xcel. You made several statements. You prefer one over another one. But my crux of the question is, what decision option will prioritize this process if you keep it as it is? Rather than your preference, I understand you like something over something, but what will make this process to fail?
Mr. Munson.
Thank you, Mr. Chair, Commissioner. I think one of the biggest issues that we see is with HOM Xcel C6, which we largely support, but it uses the word substantial in particular for if substantial costs have been incurred. I think our concern is a lack of sort of certainty on what that threshold would be, and would prefer something that's a bit more, objective if it's like a percentage cost or percentage of the total cost that's been expended or something to that effect, just so that we have a better certainty on, the likelihood or our ability to comply with the order as it would be for projects that would need reapproval.
Okay, thank you. Under that circumstance, are you worried about denial of cost recovery in that? I don't see that in that whole decision option or the framework. I don't think we are contemplating denial of the cost recovery. So if that was your concern, I understand, yes, that will be a deal breaker. But the intention is if, let's say you spend about $100,000 for the certain project, we may need to reevaluate it. That doesn't mean that we are not going to reject cost recovery of it. It's like if you try to recover certain costs, always we go through the prudency review. Regardless of we revisit this project or not, doesn't matter. We will revisit overall with the cost prudency review anyway. So I don't perceive that option is saying that we are going to reject cost recovery in that, even if we are re-evaluating it. Even if we re-evaluate the project, we decide not to do it, still you have a right to recover that cost if it was happening prudently. For example, in my view, I don't do second guess. If you did it with a good faith effort of the forecasted information, we should allow you to recover that cost.
That's what confused me, is that he puts in the word substantial, which seemed to me you would want that word. because it's, if it's just an impact, then we're going to reopen it and we're going to look at prudency and everything. It seems as I'm almost saying to the commission, and we're okay with you, moving in here and there, but if it's substantial, we're going to take a look at it. So it's almost like a finding we almost have to come up with, is that there was a substantial impact, not just a minor impact. So help me out. I appreciate your dialogue here.
Mr. Chair, I appreciate that question. Yeah, I think that's part of ultimately our concern, is that understand there may be circumstances that arise where a project needs to go through reapproval and that it may no longer be approved. And if we've already started construction, there may continue to be trailing costs. And so if substantial is a significant portion of the originally estimated cost of the project, we could be well into construction of the project and have to continue to incur costs just to sort of put the system back together again, or there could be additional costs just from materials that have been ordered. I think that's the real concern that we have, but appreciating that there is at least an intent that there's still a path to cost recovery of the original costs that were incurred in good faith.
Yeah, I mean, that's why I think in the regulatory process, documentation is everything. If you can verify your prudent spending on the project with the documentation, I don't know whether anybody can challenge that. So given that you have a good documentation, how you plan that, and then you implement that plan, and then, yes, I understand you have to sometimes pre-order certain things. So, I understand there is a concern with the regulatory uncertainty, but I think all along, I think my intention, at least, I don't know about other commissioners' intention, but my intention is trying to give you as much as certainty possible. Being said, also we have to have a prudent regulatory prudency review. So that's why I was hoping that we have a certain threshold with not very clear, but you can make your judgment call. But given that still you can stop project and ask for the cost recovery. It is nothing different from the FERC on this transmission line project. I'll just borrow that. Yes, you can ask for the recovery of stop project in the federal process too. Same thing here. If you prudently incur your cost, you can ask for that. I understand there's a concern with the used and useful principle, and there was a challenge on that part. So that's why we have to be very careful about overall situation. But I think that if you try to, I think same token that the other side will ask you a lot stringent restriction on you guys, and that you want less stringent requirement here. That's why I'm trying to find in the middle ground, and this is what I found. So hopefully it's not going to prioritize your intention to work on this one, because it's not going to help ratepayers, but it's going to help you guys, because you guys need to develop the virtual power plant on the ILP order. This can be part of that process too. So that's why I hope company takes this as non-essential rejection reason for this.
Commissioner Partridge, or did you want to respond? I didn't want to cut you off. It sounded more like a statement than a question. So.
Thank you, Chair Tuma. So I actually read this and had some concerns about the language in C6 in all its different iterations. And my concern is simply that, to my knowledge, as everyone knows, I'm fairly new as a commissioner, but to my knowledge, we don't do reapprovals. We approve, and the idea that we would ever reapprove calls into question what approval means in my mind. So I was thinking of this more as a request for modification would be an appropriate way to go, that you go through one stage of approvals, and then with your next filing, if you needed to make a modification due to a change in forecast or change in, whatever conditions it might be that initiate this need, you would be able to bring it to the commission and request a modification. I wanted to throw that out there for consideration by my colleagues, and I did draft up a potential decision option for your consideration. I just really am concerned about creating a new regulatory term of reapproval. I don't think we have that process in place anywhere. And again, it just, for me, I wouldn't think we ever need to reapprove. We go through a rigorous process to evaluate and approve projects. And the concept, I think, in the decision option, which I believe we have available and we can put on screen, the idea is just to provide some flexibility where people can, oh, thank you, Ms. Twilliger has it in writing or on paper. Thank you. So for the folks in the back trying to squint and read the screen, it reads, if the company wishes to propose significant changes to an approved proactive upgrade project, Xcel shall request a modification to the project through a subsequent proactive upgrade proposal with a detailed explanation and justification for the proposed changes, including changes to the forecast that impacts the need for the project. And then it uses the same definition as is in C6 that says significant changes include scope changes to the project that would impact overall cost, timing, location, or technologies associated with the project. I don't know if that meets everyone's needs or anyone's needs, but that was something that I noted as I went through the framework.
I assume you want to hear from Xcel first. Anybody else?
Yeah.
So Xcel.
Mr. Chair, Commissioner, I really appreciate this new alternative, and I think we would be happy to support it.
Mr. Schultz, you're looking
Mr. Chair,
thoughtful there, so I'll ask you first.
No, the OAG doesn't have any. I don't think we have any issue with this. This looks fine to me.
Dr. Lieb.
The department is also fine with this decision option.
Okay.
Good.
Commissioner Hom, I don't know if you have any questions that you wanted to ask on it.
No, I mean, once again, I'm not here to take a strong position one way or another. If the two party who has the duty and strong incentive to protect the ratepayers' interest say yes and companies say yes, then why not?
Well, and I like to say that because I was struggling with reapproval too. I didn't really know what that meant. I was kind of putting it in this context and not a broader context, but I appreciate you pulling us out of the weeds, Commissioner.
I mean, even if under this condition, if Xcel file documents, we have to go through some sort of re-evaluation process anyway. That's why language itself is not going to change a lot. But at the end of the day, change of circumstance come to the commission. We are not just going to accept it. Department will make a comment, OAG will make a comment. So there is a certain process will go on one way or another. So that's why I'm not hanging on to certain language here. But if everybody agree with it, I'm good.
Where do you want to take us next, Commissioner Hom?
No, if Xcel doesn't have any other item that which will prioritize this project, I think I can just make a motion.
Let's just make sure Commissioner Partridge or Commissioner Sullivan don't have any general questions before we get to deliberations. Commissioner Sullivan, do you have anything? You good?
I'm all good. Thank you.
Commissioner Partridge, I'm seeing you're shuffling through papers, so I went to Joe first to give you some time, but he didn't help you out.
Okay, I made it. I got there. Okay, my only other comment was just on the distributed generation engagement group. In Commissioner Hom's motion, this would be discussed in phase 2, and there's record about kind of the makeup of that group, and I think our staff did a really nice job of explaining that we as a commission have no authority to require anyone who is, a private entity to go to a work group. We can't tell any distributed generation provider who has 50% of their business with residential or commercial to show up. So I just was curious Commissioner Hom about your thinking of how they should discuss this group. I also was moved by the fact that the developers are welcome to attend these stakeholder groups and voice their opinion. So I wonder what you were thinking about the need for this extra group of developers to have their voice in the mix.
Commissioner Hom.
Yeah, thank you, Commissioner Tuma. Okay, stakeholder process is about trying to get some discussion and consensus. I understand we cannot compel anybody to come to the meeting and then make their opinion, but I hope this is a more proactive, more positive angled process. Because to me, it is good for everybody as long as we are making sure that this cost allocation is fair to the existing customer and it is not being shifted to the non-participating customer. Being said, once again, if you have a good language, please suggest on alternatives, or if you think we should strike it out, that's okay too. But I think it'll be more community-like discussion so we can bring more people to it. But I agree with you that we cannot compel anybody to show up.
Sure. So I'm comfortable including it. I guess I would just say, and this won't need to be in the order, but for everyone listening that, you know, it's worth discussing how developers can provide their input, but keeping in mind that the commission doesn't have any authority over developers. And so we cannot tell them what to do, where to show up, and all of those things. So please, in your wish list during phase 2, keep that in mind.
Any further questions? I'm looking at, I think, a universal motion. I don't know if we need to do, question 1 or 2. I think we could get a universal motion out first. So why don't we start with that? But Commissioner, working off of your revised decision option.
I
Okay.
think we had one
Looks like Xcel has a question.
hand up.
Thank you, Mr. Chair. I apologize for interrupting. I just wanted to raise one additional concern that we had with the framework in the proposed motion was between JD versus JE options, and our strong preferences for JE as opposed to JD to align with how investments are typically treated in our practice.
Commissioner Hom.
Okay, thank you, Commissioner Tuma. Once again, so I made clear, not just preference, why does it harm your investment? So that was my question. Why it will create a negative circumstance for your investment on this?
Thanks, Commissioner Hom. This is Tom Mammon with Xcel Energy. I'm a rate analyst. I've been working on the framework. So, Commissioner Hom, you were saying earlier that you wanted this framework to be something swift and kind of fluid, and JD would require the utility to stand up potentially new systems and processes that might significantly delay and kind of work and give the utility another kind of barrier to evaluate as it's putting forth a proactive distribution grid upgrade. So what JE does is kind of more in sync, synchronizes kind of what the framework is trying to do with what we already do as a utility with experience in terms of true-up filings and credits back to customers against the revenue requirement. That kind of fits neatly into what we already do, and so we can more quickly roll out this framework and proactive upgrade proposals, knowing that we have this kind of pathway set in place.
Okay, thank you. So in other words, it's not about the financial industry will have a second thought if we have a JD over JE, but you think it can improve the process?
That's correct. In conversations I've had with our capital accounting, we would have to significantly lay out a process that we still don't know yet today on how we would actually do this as a utility with an asset that its valuation changes over a specified time. So we would need potentially considerable time to figure that out and potentially administrative costs to kind of accommodate just this one kind of aspect, because it's kind of a novel idea in this sense where it's a utility directed investment. So it would probably delay our proposal kind of.
So fresh energy, I'm looking at page 43 of my briefing papers. I got fresh energy, Mencia, and ELPC. I don't know if you guys want to comment on the discussion between JD and JE and what Xcel is saying. I'm hearing a lot of people jumping in here, Commissioner Holmes. I don't know how much I should be patient. Schultz.
Mr. Chair, Peter Schultz with the OAG. I think that the current proposal by Commissioner Hom with JD is something that we push for in the work group, and it's simply to treat cost share fees in a similar way that contributions in native construction are currently treated, which we see the cost share fees is sort of analogous to kayak because it's the customer who's actually directly using the facility, kicking in some money. And with kayak, those are treated as an offset to rate base, or, and we're not understanding how, excuse me, that would be an unusual thing to do. I mean, that's what they do with kayak. I'm not an accountant, but they record the payment from the customer as an offset to the capital investment. So I'm a little surprised to hear that this is going to take a huge delay in the process.
Mr. Hom.
Okay, thank you, Commissioner Tuma. So I understand concept, but also I understand your financial incentive because you want to rate base everything rather than you depreciate it or spend out. Being said, what kind of mechanical mechanism you need to change to accommodate JD and why that's going to take so long?
Thanks for the question. So I know kayak is being referenced here, and we do that, but that is more of a reactive mechanism. So in the example of kayak, there's a specific customer and a cost share clearly defined, and that is like a one-time, we write down the asset and then set it in the depreciation models. What we're proposing here is a broad utility-driven proposal that would have an unspecified amount of cost share, and so in our kind of our internal asset planning, which doesn't account for this currently, we'd have to determine how the level of customers, and there's just a ton of variables that become unknown when you consider the proactive sense of this upgrade versus a reactive kayak investment. So I think that's where the delay is how would we kind of band all of the unknowns into a thing that would work functionally, that would also be fair to cost share customers as they come in and pay a cost share fee on an asset that is depreciating. So I think there's just a lot of unknowns with the proactive sense where there's a lot less unknowns when you consider a reactive investment and there's known customers and participants. So
now I understand. So you have to package those risks and you have to explain to the investors and then probably also internally to your boss to make sure that you are not losing money.
That's correct.
Okay, got it. So
the quality of planning that you've done. So I mean that's your concern. We haven't planned around this before. But if you do go, this is almost exactly what we're doing at SPP on the overall transmission system. Trying to do it's kind of a thinking ahead plan, but it requires very intensive, well thought out plans.
Correct, and there is a possibility with JD where the utility is not incentivized to have cost share customers because we would retain the full asset value, whereas JE, we basically flow those cost share fees directly back to customers.
SPP isn't worrying about that because they don't
Correct.
have, they don't have the rate base.
Absolutely, yep.
Schultz, give you a chance to think through this.
Yeah, excuse me. I guess, we continue to support JD for the reasons we've stated in the work group and in comments, in that it does reduce the ratepayer impact over the life of the asset because there's less return and probably less depreciation. For sure, less return over the life of the asset. So I just am not, we're not hearing strong. I mean, this is proactive upgrades are a new thing. There's undoubtedly going to be some changes that are going to need to be done in the utilities accounting for these things, and we're just not seeing how should be an obstacle.
Yeah, I think the exact same reason I was promoting JD, but I think what I hear from Xcel also, there is that uncertainty can create the delay in overall process. I think now we have to weigh this one in two different groups, trying to fine tune more and then delay this process, or should we proceed with a little bit of that? I understand fully rate basing versus depreciating upfront is very different, but also Xcel says, not knowing who's going to contribute their money, how can we fully depreciate upfront? They have to rate base upfront if there's nobody showing up upfront. I think that's what Xcel is trying to say. When there's nobody at this point, they're making a plan, they have to rate base everything, and then they will start to depreciate it. In that process, there are uncertainties. And then they have to finance this. Even if it's not a lot of money, but overall their financing scheme, it can contribute to the new risk. And it'll have a negative impact to everything. You understand that risk to the utility will not only impact this specific project, but it can potentially impact whole package.
Sorry, I didn't catch the last part. It'll also potentially impact all.
I mean, the accumulation of different small risks can have a snowball impact to the overall company's risk profile.
Commissioner Hom, Mr. Chair, Commissioner Hom, I don't know that these are going to be a large component of the company's investments, at least initially, and certainly could be revisited in the future how they're accounted for. But yeah, I mean, I can sort of understand some of their concerns. I don't really think it changes our view.
Okay, thank you. How about department?
Chair, Commissioner Hom, the department didn't take an opinion on this in general, as we don't see a significant difference, but I think, Nancy Campbell, if you're online, if you want to offer any additional color on a slight preference to one or the other.
Ms. Campbell with us.
Yeah, can you hear? There we go.
Yep.
Can you hear me?
Clear. Loud and clear.
Nancy Campbell for the Department of Commerce. I don't think we have a strong preference. However, if we're talking about rate basing the costs, then it does seem like we would want to do the credit to the rate base, like contribution to native construction, like in JD, unless there's a strong reason for not doing that. So that would be the only concern that I would have. I wouldn't want ratepayers to be negatively impacted by not doing that. But the most important thing is to make sure that customers would get the credits back and not just pay the cost.
Commissioner Hom.
Thank you, Commissioner Tuma. Okay, let's say you rate base $100 today, and then somebody shows up tomorrow and say, yeah, we will pay $10. Until tomorrow, there is a financial cost, so rate of return or borrowing cost. Who will bear that cost for that $10 portion of it?
Well, I think that's why you want to do it under JD potentially, because hopefully you'll apply the $10 credit to the 100 and we're only rate basing 90, right?
No, but we rate base upfront 100 anyway. So that's why my concern is after 1 year, after you rate base everything, what will happen in year one. So year zero, you rate base everything, and the year one, somebody shows up and they take the $10 out of it. What'll happen? So I think the department prefer JD under that circumstance. Now I would like to hear from the company.
Yeah, so this gets into the hairy bits of how do we depreciate a declining asset balance on our utility system, which has not, to my knowledge, happened. We have kayak, but again, that's a point in time, one time drawdown of an asset, and then we put it in our depreciation tables and off it goes. This would require a very robust process to track the incremental cost drawdowns of the asset balance over time, and the reporting on it, and the relation with the programmatic fees. There's a lot of things that are good in the framework that would make this really, with JD, really complicated internal process to then facilitate this proactive process, right? It's a capital asset process that we'd have to stand up from scratch. I understand the ratepayer protections, and I do think there are measures elsewhere in the framework that more easily address ratepayer protections, but I think internally we would really struggle with standing up a process quickly that would make us comfortable putting forward a proactive upgrade proposal.
Okay, thank you.
Anything further to add, Ms. Campbell?
Yeah, I guess I don't understand why it would be that complicated if the idea is, okay, in the example, if you get the $10 in year one, once you update your rates, couldn't you just apply that credit to that rate base at that time?
So?
Yeah, so thanks for the question. Now we're getting into the bits of where I'm not the expert capital asset accounting person, so apologies. I agree in theory, but when we're talking about utility systems and significant amounts of assets on our books and group depreciation, it's a bit of a spider web, and we're talking about a hypothetical one example. I don't really have an answer that's that's definitive to your. It's not an easy thing when talking to our experts. It would require a lot of nuance, system nuance, and we don't really have a cost at what it would require in order to administratively set up something like that. Is all. So I guess JD just opens up an unknown that we'd have to figure out before we would be comfortable putting forward a proactive proposal. And so I guess that's our only concern with JD. Whereas JE is, we know how to do all of the things in there to quickly stand up a proactive
So if I understand what you're saying is, this is a big thing. We probably could track it, but if it's because we're talking about a lot of small things, it might end up being a lot more difficult than we think it will be. That's kind of what I'm hearing from you.
Correct. Yep.
Commissioner Hom.
Yeah, thank you, Commissioner Tuma. Can I have 5-10 minutes so I can consult with our staff?
We will take a recess until, let's go 22. So, recess. Assuming that
There we go.
Mary can turn us back on and Joe can hear us. Are you back there, Joe? Commissioner Sullivan. Did you go to your garden again, Mr. Commissioner Sullivan? Or? There he is. Okay, Commissioner Hom, I think a couple more questions, then we're going to start putting this plane in the landing gear down and get her on the ground.
Yeah, thank you, Commissioner Tuma. Okay, to the Xcel. So if I change my motion from my C6 to new Partridge C6, and then change from JD to the JE, do you have any other deal breaker?
Mr. Munson.
Mr. Chair, Commissioner, not a deal breaker, but there is an item that J12 that was excluded from the proposed motion that we're just hoping to seek clarification on what that would imply with how the cap would be administered. Because I think that was something that in the work group process, we had sort of a decent number of stakeholders had kind of agreed this clarification on sort of what happens when a cost share window ends and how it frees up that space in the cap. So it's just unclear sort of like how the cap would function without having J12 included.
I think on the J10, we still need to discuss about cap, right?
Commissioner Hom, I think if you wanted to hear more about J12, you could just, it could be part of a proposal under J10 since that has to be made anyways, just have a holistic proposal for how the cap would function under J10 and then could have more consideration of it at that time.
So any language or it's just as is?
Are you okay with that, just understanding what do you want language in there? And then we need more time to change, we need to change the language.
Mr. Chair, Commissioner, we would be okay with that being as part of that J10 proposal, or part of that first proposal per J10.
An understanding. No need to new language, right?
Correct. Yep.
Okay, and then party who was pursuing JD, I think we are going to do JE today, but JD will be part of the phase 2. So since we have some time until actual project, significant number of projects will show up, so I think we can still discuss JD in the phase 2. Under that understanding, I hope you are okay with the JE.
Mr. Chair, Commissioner Hom, that's helpful. I think we're still a little unclear as to what happens in the interim period if the projects start, go into service and cost recovery starts, but maybe that won't happen. So that's the only question I have.
Yeah, I mean, that's why I think in the beginning, that's why I mentioned that we need to make it happen sooner than later, because given all those uncertainty we are getting from federal government, we need to move quick. So I think that's the essence of my motion, and that's why we do the JE today and then do the JD in the phase 2, making sure that you guys can figure it out outside this proceeding.
Okay, seats in upright position. Buckle up. Commissioner Hom.
Yes, then I can make a motion.
No, I'm ready for you. No, I just lean forward to support his motion in advance.
Seat forward, I see it. Good. Thank you, Commissioner Partridge.
So I can make a motion as a package, hold my package with the 2 modification. New Partridge C6 will replace C6 portion, and then JD will be stricken out, and then JE will replace it.
You have that?
Okay, and then also one clarification, I got a strict order from our staff that C10 and G14 will adopt all subsection of it in that framework.
So that's G14 under
C10 and G14 in the framework section, not in the motion section. That is a subsection of it. It's just a clarification.
And that was G. I got G14. What was the other one?
C10.
C10.
Yeah.
Okay. Got it. All subsections. Okay. Commissioners, any question on the motion in front of us? I'm working off again the HOM revised decision option and proposed motion that he's just modified. Mr. Sullivan, you good? Mr. Partridge, we're rocking and rolling. We are ready for a vote unless I hear anybody screaming from the back of the room. I don't. So, Commissioner Partridge.
Aye.
Commissioner Hom.
Yes.
Commissioner Sullivan.
Yes.
I also vote yes. The vote is unanimous. My plan is we are going to we're going to actually adjourn this meeting. So we're adjourned. And then we are going to start the special meeting in a couple minutes, just to get everybody to kind of clear out. So pretty quickly, but so just so you know, those over here for the special meeting on MISO errors, we will start here in 2 minutes. And thank you all for your hard work. That was a good job.
I feel like I should frame this.
Thanks for using WebEx. Visit our website at www.webex.org.